Yeah. All right, ladies and gentlemen, I have about 9 a.m. Start by calling the criminal dockets. As for announcements from the attorneys, anyone who's present who doesn't have an attorney or your attorney doesn't answer for you, please make sure I know that you're here. And if you're not doing that, please make sure that your phone is muted. Pardon me, State versus Jacob Flores.
And Your Honor, that counsel's present. He's in custody in Wilson County, and that case is likely on trial track. So I'll be messaging you a new date.
Okay. Jacob Anthony Gonzalez is in custody, I believe.
That's going to be a plea this morning, Judge.
Chance Dylan Bush. I see you, sir. We'll wait on Mr. Keendaws. Nicholas Moreno is in custody. Waiting on Mr. Keendaws. Land Rutledge.
And Your Honor, I spoke with Ms. De La Garza this morning. She is actually in court in another county. She said she would jump in as soon as possible for us.
All right. Is Mr. Rutledge here? I'll mark him a no-show. Dimitri Ortiz.
Good morning, Your Honor. Dante Dominguez for Mr. Ortiz, who is present here in my office.
Mark, you confirming.
Thank you, Your Honor.
Fidel Trevino Jr.
Good morning, Your Honor.
All right, I thought I saw Mr. Baird. We'll check on him.
Yes, sir.
Diego Amezquita.
I'm present on that, Judge. I'm not sure if Mr. Amezquita is logged in yet, but we'll be confirming with the state. Okay, there he is.
Let me rename that. Okay, I'll mark you conferring. Cassidy Dunson.
Judge, she should be logged on. We have a plea offer. We do not have a deal in place at this time. We'd like to go ahead and set that for trial, and we'll continue to try to work towards resolution in the meantime.
All right. Cassidy Dunson online?
Yes, sir.
Okay, I see you. Scott Schindler.
Good morning, Your Honor. Counsel's present on that. I'm trying to look for him. I don't see.
All right, I'll recall, mark him no-show. John Gilbert
Thank you,
Brown.
Your Honor, I know.
Present, Your Honor.
There he is. We are on. We
Thank
are
you.
ready. We have spoken with the state. We want to continue on with the trial, Your Honor.
All right, Mr. Brown, please remove your hat.
Sure.
Heather Cruz.
Thank you.
I'm present for her, Your Honor. I spoke with her recently. I'm not sure if she's on yet, but she should be on shortly, and we'll confer.
All right, is Heather Cruz online? Okay, I see someone with a phone that says Aristo 4 in a blue shirt. Is that Heather Cruz? Is that your client, you think? Aristo 4? I don't know if you can see her in a blue blouse.
Your Honor, that is Heather Cruz.
Okay, change the name. I'll mark her present. All right, Justin Daniels is in custody.
Yes, Your Honor. That'll probably just, we'll need trial dates for that unless we can work it out at some point.
Okay. Anthony Wayne Davis is in custody.
Correct, Your Honor. We'll confer.
Ashley Eldridge.
She's logged on, Judge. We're trying to work that out, but we've not been able to. I'd like to set that for trial, and we'll continue to do what we can.
All right. Joshua Esquivel.
I'm present for him, Your Honor. I don't know if he's on. I looked through the screens, but I didn't see him. I will contact him and let him know that he needs to check in.
All right. Joshua Esquivel. Mark him no show. Brandy Gibbons.
I'm here.
Your Honor, did you see, it says WC District Clerk Civil.
Okay. And who is that? Is that Mr. Esquivel?
That is Brandy Gibbons.
That's
Okay.
me. I'm here.
Okay. All right. Okay. I'll mark you present. We're waiting on Ms. Keendaws. Gregory Hobson.
I'm present for him, Judge. He's on here. I just saw him. We're conferring. I'm thinking we're going to need a new date.
All right. Mr. Hobson, I thought I saw that name also.
I'm here.
There you are. Okay. Thank you. I'll mark you present.
Once I get the date, Judge, may we be excused?
Yes. Cameron Mathewson. Cameron
Your Honor-
Mathewson. Yes.
Your Honor, the last time that Mr. Matheson was set for the docket, he was actually, his attorney, he was in treatment. I do not know if he's still in treatment.
All right. Mr. Mathewson was in treatment?
Yes, Your Honor, I believe, yes.
All right. We'll have to get in touch with Mr. Fiegel. Jonathan Montoya.
Yes, Your Honor. Defense counsel has not had any contact with Mr. Montoya in over a month since our last setting.
All right. Mr. Montoya. No show. All right. Nicholas Moreno's in custody. We're waiting on Mr. Keendaws. Stephen Orr.
Your Honor,
Present.
counsel present.
Yes. Yes, I'm here.
Oh, I'm sorry. This is Mr. Rodriguez's case. My mistake, Judge.
I'm present, Your Honor, and I believe he is on the line.
Yes, I'm Stephen Orr. I'm here.
Okay, let me rename that. And let me change the attorney's name. Okay, I'll mark you conferring. Cole Pavlik or Pollock?
We're present, Your Honor. He's here in my office with me. We'll confer with the state.
All right, thank you. I'll mark you conferring. Corey Pinshorn.
I'm here, sir.
She's present with counsel, Your Honor. We'll confer.
Christopher Rodriguez.
Here. Your Honor, he is present with counsel this morning. We'll confer.
Okay, and where did he answer? Mr. Rodriguez?
Yes.
All
He's
right.
labeled Christopher Rodriguez, Judge.
Okay, I'm sorry. It usually pops up. There it is, the yellow band around it, but he spoke so quickly I didn't notice it. Okay. Land David Rutledge again. I think I saw Ms. De La Garza sign on. Kimberly De La Garza. All right, I guess she's having trouble. She's signed on at least twice. No show. Anthony Sweatspell.
Your Honor, I'm here on his behalf. Anthony, we do have an agreement, but I had gotten the wrong email address. Can we do a short reset for a plea? Whatever the next setting is, we'll do the plea.
All right, was he here in court last time?
Yes.
Sure.
Yes.
All right, I'll mark you conferring with the state and mark him no show for right now.
Oh, he's here, Your Honor.
Tell him you're here. Tell
Where it
the
says
judge.
3.
Here, Your Honor. Glasses with long hair.
Raise your hand so he could see you.
Okay, it says 3 officers. Okay, where are you at, sir?
He's at home, Your Honor.
We can call her with that, but also instead of the police
Judge
report, I
knows
think we
that that's
can
what
use
he's looking for sweat spell right now. He's over there.
Okay.
All right, and if you're not actively speaking to me, you need to be muted. I just had to mute 2 people. Tina DeLace?
Your Honor, I believe it's De La Cerda.
Probably, it cuts off the name. De La Cerda, okay?
She is
With counsel, she's the phone number 588, Judge.
And if you could mark us conferring.
Yes.
Dan, you're going to be the lead attorney on this one?
Yes. And I work with Steve, so I think we'll send out some additional notices of appearance for me.
All right, Jeremy Saunders?
Yes, sir.
Present with counsel, Your Honor. And we are conferring.
Okay. All right, and who is the actual attorney of record for Mr. Saunders?
Judge, it's me. Monica works in my office as well, Judge.
Okay, that's fine. I just, sometimes y'all are answering for each other and sometimes not, so that's fine.
Yeah, Monica works with us and Dan works with us as well.
Yes.
Grace Rocha?
Yes, ma'am.
Your Honor, counsel's present. I don't know if she's on. She had contacted me about a medical issue. Let me check on her.
Okay, marker no show for right now, recall. Zachary Trainer?
Your Honor, I'm here on behalf of Zachary Trainer's case. I don't see him. I know he's on here, but I can't see his face.
All right, Zachary Trainer?
Yeah, I'm here. My apologies.
All right, and I skipped Misty Dawn Diaz, it looks like.
Your Honor, I believe that was reset with, she has multiple cases. I believe another case was set last week, so we have combined everything.
And they're reset to January 6th.
And we have not received a waiver of arraignment on CRW 2009-232. We did receive on her other case, but not this one. She has not been arraigned.
Okay, well, let's contact Ms. Foyt about that. I'm not going to call a nice side just if she's appearing in other cases and was told that she was reset, but thank you for letting me know. All right, Noah Lee Ramos?
He is present with counsel this morning, Your Honor.
Daniel Ramirez?
Judge, you ordered him to be there in person. He failed to appear last time. I don't know if he's there. He's been very uncooperative and.
Okay. We will call his name outside.
Thank you.
Leticia Pedroza?
Your Honor, that's monitoring arraignment. She did submit the waiver arraignment, and it's set for December 9th.
That is correct.
All right, thank you. That's all the criminal cases we have, but half of the civil docket is writs of habeas corpus. So let's see, Wilson County additions, In re Jacob Trevino.
And Your Honor, Mr. Nitz has 3 other counties that he's attending. He said he probably won't log into about 11.
All right. Atascosa County, State of Texas, it's In re Jimmy Underwood.
Judge Ellison is taking the Atascosa docket, Your Honor.
Oh, he's got that, well, so he has that civil docket, but I have the San Miguel
That is correct, yes, sir.
one, okay. All right, then I'll want to make Norma, the host. I asked you to make me the co-host so that you can get in touch with Norma for breakout rooms, and I'll release the attorneys for the state, any attorneys with no civil matters in the docket. And on the civil docket in Wilson County, 118508, in the interest of several children whose name ends in T. Eric Wilson, Brooke Irie.
That setting was dropped, Your Honor, reset upon request.
Excellent. 183168, in the interest of the Munzler children.
Your Honor, I'm present for respondent Sharon Munzler.
Elizabeth McLaughlin, present for the movement, Kevin Munzler.
Okay. And what do we need to hear this morning?
If we could confer briefly, we did begin conferring yesterday, but we still need to work out a couple of things. If
All right. All right.
Can you put us in a breakout room?
No, because I made Norma the host, but if you'll get with, yes, she may. And I'm going to have to reboot my computer because I'm having issues. My Acrobat is just barely working, and it'll be a little shorter in the long run if I reboot. Priscilla Salas versus Angelita Romero and Isidro Romero.
Your Honor, we just need a few minutes. That's a motion to compel mediation. Mr.
Yes, sir.
Opposing counsel on there.
Okay. All right. And okay, so I'll mark you number one. American Express versus Leonard May.
Setting has been dropped, Your Honor.
Matter of the marriage of Jordan and Pamela Hutto.
The case has been reset to January 6th, Your Honor.
And Judge, I do have a motion and an order to withdraw an e-file that I will be forwarding over to the e-file queue shortly.
All right, for who to withdraw?
I believe Mr. Ceballos.
All right. Okay, in the interest of Selena and Jaylee Talamantes.
Your Honor, I thought opposing counsel had submitted that order. I'll check with opposing counsel on that.
We do have the temporary orders in e-file. Those will also be forwarded to the queue shortly.
All right, thank you. Matter of the marriage of Kurtz.
Judge, I got a message from opposing counsel. He's got a medical emergency, so I'm asking to, I guess, reset the case.
Okay, to a particular date or?
I'm yes, Judge. The sooner the better, but I just obviously I want to extend my courtesies to opposing counsel. I hope he gets better, but yeah, I'd like to. Should I get with the coordinator to get some available dates?
Please. So do you mean to just put reset on request or?
Yeah, that's fine, Judge, and we'll just call the court today and try to get it reset ASAP.
All right, sounds good.
Thank you, Judge. May I be excused?
You're excused. The matter of the marriage of Jonathan Gardner.
Setting has been dropped, Your Honor. They're going to go to mediation.
Matter of the marriage of Lisa and Jacob McBee.
Drop setting, reset upon request, mediation as well.
All right, AG case, Landon and Lane Elias.
Present on that, Your Honor. Can we have Jacob Elias called? I don't see him in the Zoom.
All right, I don't see the bailiffs online. They are sometimes, so let me ask them to call that shortly.
And Your Honor, I am present for the state on that matter as well.
Okay. Here comes Mr. Keendaws. Okay, let me make a note. Elias. Matter of the marriage of Nelly and Pablo Rivera.
Present, Your Honor.
All right, and are you ready to proceed, ma'am?
Yes.
All right.
And Judge, the divorce decree on Riviera is loose in the file, and the file should be in the box in your at your bench.
Okay, I will. I'll mark that A. You'll be the first self-represented case I call when I get back from rebooting my computer, and I'll look at the file. All right, and I've received a breakout room for number 17. I assume that's an error.
It is, Your Honor.
It's easy to click the wrong box. Okay, and anyone else told to be here today? Your case was not called.
Your Honor, just to inform you, Gracia is present. Her phone number ends in 620. She's muted, but she is present.
Okay, who's present?
Grace Rocha.
Ms. Rocha, okay. All right, her phone number ends in
620. She was just on. I just saw her.
I see one that ends in 630.
That's not her. It's 620. She was just on. Let me check. I don't know
Okay.
if she hung up, but she was just
We
on.
just went down from 3 screens to 2 on me. So yeah, somebody dropped out. Okay, then yes?
Hello?
Yes. All right, Ms. De La Cerda, I'm gonna mute your phone. You were marked present.
2.
All right, so I'm going to leave the meeting. I have to reboot my computer. That usually takes 7, 8 minutes, sometimes longer. I shall return. Attorneys to confer until then.
Norma.
Norma or Cindy, do we have a reset date for cases we're setting for trial?
Give me just a second. I'm going to post them. I'm having issues with the breakout rooms. If you'll hold just a little bit.
For sure, absolutely. Thank you.
Thank you.
Norma,
Yes, ma'am.
is there an civil ads docket for Wilson County?
No, ma'am.
Okay. We had one case that was a writ of habeas corpus, HCW. There was an ads docket attached in your website yesterday.
I'm sorry. Yes, there was on Jacob Trevino.
Yes.
Yes, ma'am. It is on there.
Okay. Judge didn't call that one, so when he gets back on, he'll need to call that case.
Yeah, he did. He called it.
Oh, he did?
I let him. Yes, ma'am. I let him know that Mr. Nitz was going to be late about 11.
Oh, okay. Okay. I'm sorry I missed that.
No, it's okay.
Thank you.
Yes, ma'am.
So you can take the oh. I'm still waiting for Sally. Okay. Does she pay cash or check? Check? Okay.
So the check's in the bag.
All right.
I texted Michael Covier, I called him, no answer, so I texted him, he's like, take it tomorrow. It's ready, I told him to pick it up later today. It's $16 here.
Another one?
Yeah, he has it, $16. So I
Okay.
will hang that on my phone.
Okay.
Norma, after we post the cause number, name reset in chat, are our clients excused?
Yes, sir.
Okay. And then I logged on a little bit late. Do you have the plea paperwork for James Gonzalez? It was e-filed and accepted.
You probably send it to Cindy.
I have it, Adrian.
Okay, we're ready on that whenever judges and y'all.
Yeah, I'm
Okay?
still waiting on a judgment. I haven't gotten a judgment from the DA's office. As soon as they have it, they're going to send it to me. So we're
Very
not
good.
ready yet.
No problem. I'm just making sure you weren't waiting on me.
Okay, no, you're good.
Thanks.
Norma, did you say once we post the name and the date, we can leave?
Yes, sir. As long as you post it where I can see it as well, and Judge Wilson.
All right, thank you.
Thanks, sir.
Norma, I have forwarded the two cases, the Hutto 1901-023, the order to withdraw for Mr. Cedeos. I've forwarded that through e-file to your queue. If you could forward that to Judge. And then also on Talamontes 1902-180, the temporary orders.
Okay. Yes, ma'am. I'll go ahead and forward them.
Thank you.
Yes, ma'am.
Mr. Brown, I've given us a reset date so you can log out.
2002-20-05-0011.
Hi, Cindy, are you there?
Yes, Sean.
Okay, Chance
Bush
You're
showed
right.
up. Yes, he answered.
Yeah, because I guess they were telling him that he had to appear a probation, but he's like in Houston somewhere. Brandy Gibbons, did he show up?
Is there. It says WC District Clerk Civil. There's Brandy Gibbons. Brandy, can you wave or say something?
I'm right here.
Okay, thank you, sir.
Do you need to confer with him? Does Norman need to put y'all in a breakout room?
Yes, we can go ahead and do that.
And Sean, Mr.
Yes.
Bush knew to report to probation this morning. So I don't know why he's in Houston, but he was told to report to probation. So that may become an issue.
Oh boy. Okay. All right. We'll talk.
That's fine. I just wanted to give you that heads up.
Okay.
Mr. Dawes, who did you need a breakout room with?
Brandy Gibbons.
Okay. Yes, sir.
You see it's under the WC District Clerk Civil.
Okay.
Cindy, did Daniel Ramirez ever show up? He was ordered to show up in person.
Now, let me go and have the bailiffs call his name out there and see if he's here or not.
Thanks.
Hey, Cindy, I also want to let the court know that my client showed up.
You walked away.
Cindy stepped away from the
Yes.
who's your client?
It is Eric Scott Schindler. He is wearing a lime green shirt where it says iPhone.
Okay.
And I'll be putting the reset dates on the chat.
Okay.
Thank you.
John Brown, did you hear me?
Yes, I do, Your Honor. Yes,
Hi,
this is Mr.
this is me. You can log out. Give me a call later today, okay?
Who is this, Mr. Lambert?
This is.
So we're good. We're conducted with the court.
I will call you in a bit. Yeah, you can log off now.
Okay, brother. Thank you.
Mhm.
Can you log me off, please? Oh, just leave. I just push leave.
Yeah, for you.
Philip Lambert. Mr. Lambert. Okay. Okay.
Click.
Leave. Right? Just let me do it.
You're good.
Christina De La Cerda?
Yes.
All right, we're done. You can log off and I'll give you a call later.
Okay, thank you.
Thank you.
Adrian, Mr. Ramirez has not shown up here.
Okay, thank you.
Noah Ramos?
Yes, sir.
All right, we're good until January 6th. You can log off. I'll call you later, okay?
All right. Appreciate you, bro.
Thank you. Cindy,
Yes,
would you be able to tell me if a motion was received by your office?
I would be able to. What are you looking for?
A motion to quash on 2006000149W.
Let me look at that real quick.
All right, thank you.
Yes, Dan, it did come into e-file this morning and I did forward it over to the judge's queue.
Okay, thank you.
Mhm.
Mr. Hay.
Ms. Norman, now that I've requested that new date, may we be excused?
Yes, as long as you post it where I can see it.
Okay, will do. Thank you, ma'am.
Thank you.
All right, you're good to go.
Zachary, Trainer,
Yes, sir.
we're excused until January 6th,
Copy that. Thank you.
and I will call you later, okay?
Sounds good. Thank you.
Thank you.
Fidel Trevino, dates have been posted for you. You're free to go. I can't hear you. You're muted.
I said, thank you, ma'am. I appreciate you.
Okay, you're welcome.
Thank you. Bye-bye. Okay. Yeah, that's it, all right. Maybe. Shit.
Mr. Trevino, remute yourself.
I'll try to. I'll try to right now.
Okay, just
Okay.
hang up the call and it should end.
Okay, there we go. I think, and then that is screw it. Okay. All right, do this.
Hi, Cindy. Can I have a breakout room with Lorena if she's available?
Norma will do those.
I will get you breakout room number 4, Mr. Dawes.
Okay, thank you.
Yes, sir.
Norma, could I get a breakout room with Attorney General Lauren Reed, please?
Who was in a breakout room?
And Jameson with Lauren Reed.
You'll be in breakout room number 5.
Thank you.
Yes, ma'am.
Daniel Ramirez, are you online?
You're muted, Mr. Ramirez.
Mr. Ramirez, if you could hear me, last court date, Judge Wilson ordered that you go to Wilson County Justice Center in person for today's meeting. Can you get over there today so he doesn't mark you as absent, please? Mike, you're muted. The microphone's in the bottom left corner.
Dan Ramirez, can you please unclick your mute button? Looks like a microphone, and unclick your video so that we can see you, please.
I was muted. All right, Mr. Cedillos. Okay,
Yes, Your Honor.
on that Salas versus Romero case, are we ready on the motion?
I'm ready, Your Honor.
Yes, sir. We're ready. Mr. Kiloita for Romero.
All right, what sort of case is this?
Your Honor, this is a lawsuit from my client, Priscilla Salas, filed it against her mother. This was an eviction of a house that was on her property. It's been on her property for 30 years, and I won't. That's about all I'll say. But there were a lot of improvements, so we think this case would be better suited in mediation, trying to work it out, because this is a mother and daughter case, and we'd like to go to mediation. We tried it once before, but I got tied up in the family law court, and then the mediator could no longer wait, and we were tying up Mr. Opposing counsel and his clients. And I got released about 5:30 from that family law case. So we'd like to try mediation again.
All right, and what says the defendant?
Mr. Cedillos is correct. We did try mediation, but that was over a year ago, almost to the day, almost in October. And so, had we rescheduled right away, I don't think my clients would have had a problem. My clients are old, are a little bit up there in age, and they're very concerned about leaving their home. So they've instructed me that they just don't want to mediate if they have to leave their home. I tried to explain to them about the Zoom platform, but they're just not willing to mediate. So
Okay, and I take it that do you have a laptop? Could you either travel to their residence with a laptop or have somebody take a laptop over there and set it up for them?
Sure, I have no problem with that. That's not a problem. It's we're ready to proceed to trial though, so that's our position. But if the court would,
But is it going to be a jury trial or a bench or?
I believe it's a bench trial. Is that right, Andy?
It's going to be a bench trial, Your Honor.
Okay, well, I thought we were supposed to have had a jury being picked Monday in Atascosa County. We already sent the notices out, had our COVID plan and everything, and then that fell through. But we're very close to resuming jury trials. There's going to be a whole lot of trials stacked up. So I will order that the parties mediate and that they do that via Zoom, or I'll just say electronically through electronic teleconference.
Yes, Your Honor.
Somebody will get me an order about that.
I'll get it to you, Your Honor.
All right, and let me make Norma the host again. I didn't realize it made me the host when I came back.
Elo, you're okay on Trent Rao?
Yes,
Again?
he's fine. Trent Rao is perfect if he's available. Yes.
Okay, I'll prepare an order.
All right, thank you. May we be excused, Your Honor?
Yes. All right, give me a chance to look at the divorce. All right. All right, calling in the matter of the marriage of Rivera.
Yes, Your Honor.
Okay. All right, and Ms. Rivera, I'm asking you to start your video. Okay,
Good morning.
good morning. And you're ready to proceed?
Yes, Your Honor.
And is Pablo Rivera present?
No.
Would you raise your right hand? Do you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
And your name is Nelly Rivera,
Yes, Your Honor.
and you're married to Pablo Rivera,
Currently, yes, Your Honor.
okay? And when did the two of you marry?
May 20th, 2000.
Okay. And when did you stop living together as husband and wife?
May 20th, 2020
Okay.
is when he picked up all of his belongings.
All right. And has the marriage between the two of you become undermined due to a discord of conflict or personalities, meaning that conflict of personalities, meaning you're just not getting along?
Yes, Your Honor. We changed.
Is there any likelihood you're going to reconcile and live together again as husband and wife?
No, Your Honor.
And how many children have been born to you since the date you were married?
3 children. 2 of them are still minors.
That's Melanie and Pablo.
That's correct. Excuse me.
And are you expecting a child at this time?
No, Your Honor.
All right. And you're asking that you be appointed joint managing conservator to the children, with you being the person who will establish where the children live?
Yes, Your Honor.
And is that pretty much what you've been doing since May?
Yes.
And where did you get the number of $400 a month for child support?
That is a mutual agreement between me and Mr. Rivera. When he left, he said that that would be the amount that he would be providing for the children's support.
All right. And I have to ask you, have you applied for government aid of any kind?
Medicaid. Children's Medicaid.
Okay.
I've also already started a case with the Attorney General's office.
Well, see, here's the issue. If I sign off on a divorce decree that sets the amount of child support, the law presumes that if any attempt is made to change the amount of child support within the first year after that decree is entered, the law just presumes that you're wasting the court's time and that you're doing it and that there doesn't need to be a change made. So we need to make sure that the child support is correct the first time. What sort of work does your husband do?
Refrigeration.
Okay. All right, and do we still have an assistant AG, Attorney General, online here?
Yes, Your Honor, I'm here.
Okay.
Good morning.
Having been on Medicaid, is that enough for the Attorney General's office to come in and take an interest in the case?
Yes, Your Honor, it is.
What I thought. I didn't know if it had changed. Okay. All right. So I'm going to ask Norma to put the two of you in a breakout shortly. I'll take your announcement on the case that you're here on, ma'am. And Mr. Rivera, what I need to tell you is whenever you apply for public aid for a minor child, part of what you're doing is that you're signing over to the state of Texas the right to go in and ask for child support from the other parent. So the Attorney General's office would need to be a part of this lawsuit just on the issue of how much the child support is. And I can tell you that, does your husband have any other children he has a legal obligation to support?
No.
Okay. I can tell you that typically there's the calculation of what a parent's take-home income is. And for 2 children, the child support would be 25% of the take-home income. And for 1 child, it would be 20%. So you have the amount of child support being cut in half whenever it goes down to 1 child. And typically, it would only go down by 20%. So I'm going to, again, take announcements from Ms. Reed in a minute. Then I'm going to ask Norma at the coordinator's office to place the two of you in a breakout room when Ms. Reed's available. So let me go back up to the top and just take announcements on all the civil cases.
Okay.
All right. In the interest of the Munsler children,
Yes, Your Honor. Yes, Ms. Tapia is on, and we would like to put on the record that we have an agreement for the temporary orders.
okay. And I will, I'll let you do that in just a moment. Let me just get the announcements. All right. Salas, I've ordered mediation. Okay, McBee, was that reset or was there just no answer? The matter of the marriage of Lisa and Jacob McBee?
I show that the setting was dropped, reset on request.
That is correct.
All right, I will ask the bailiff. Is anybody from the bailiff's office watching? I'll go and ask the bailiff to call Jacob Elias outside in just a moment. Is that the only thing you're looking at? If he does not appear, what do we need to do in that case?
Your Honor, I'd like to put on my client just for some testimony to support our requested relief, and then I can present an order to the court. I've already spoken with Ms. Reed, and I think we're in agreement as to the child support and health insurance issues.
Okay. All right. Well, I think that's the next thing up. So let me, who's your client?
My client is Ara Bear.
All right. And can we get her sworn in? Is she with you or is she on separately?
No,
There she
she's
is.
on
All
separately.
right. I see her. Ms. Bear, would you raise your right hand? Do you solemnly swear or affirm the testimony you may give in the matter now on trial will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right. Go ahead, ma'am.
Thank you, Your Honor. Ms. Bear, can you please state your full name?
R.I. Simone Royal Bear.
Okay, and where do you reside?
Right now, 200 3rd Street, Floresville, Texas, 78114. But I am in the process of moving into Cibolo, 1110 Tomahawk Circle.
Okay. And had you lived there with the children for the last 6 months?
Yes.
Floresville?
Yes.
Okay. And are you the, I guess, counter petitioner in the lawsuit that was originally filed by the Office of the Attorney General?
Yes.
And are you the mother to the children that are named in that lawsuit, Landon Elias and Lane Elias?
Yes.
How old are they?
Landon is 4 years old and Lane is 3 years old.
Okay. And who have they lived with primarily since they were born?
Myself.
What was the date of your separation from their father, Jacob Elias?
Last year, around the summertime. I'm not exactly sure the exact day.
Okay. And what has his involvement with their caretaking been like since you separated?
He's not really been around much. I have documented every time he's seen them and every time he calls, and he's been very back and forth. He'll see them a couple times and then he won't see them for months, and then he'll see them a couple times and then won't see them for months. It's very back and forth and in and out.
Okay, so on average, how often since you've separated has he seen them in a month?
About in a month or this year?
In a month.
Either not at all in a month or he'll see them once a month.
Okay, so very sporadically. Is that fair?
Yes.
Does he try to communicate with the boys at all?
Occasionally he will call, but for the most part, it's me calling him so they can talk to him.
Was there any issue with violence or domestic violence in your relationship with Mr. Elias?
Yes.
Can you describe for the court the details of the violence that you experienced in your relationship with Mr. Elias?
I'm sorry.
Take your time. Take your time, ma'am.
It started out just him pushing me and grabbing me, and it's escalated to hitting and slapping, punching. He's broken my nose. He's broken my fingers. The last time he held a knife to my neck, and he said that he was just trying to scare me. He's choked me. When I was pregnant, a few times he threw me down to the ground and would kick me in my stomach while I was pregnant with our children.
And does he have a criminal history?
He does.
What do you know about his criminal history?
Currently, he's on probation for beating another girl. In 2018, he had beat her and choked her and threatened her, and she called the cops, and he was arrested for that and is currently on probation for 6 years from that.
Okay. And does he have any issues with alcohol or drug abuse?
Alcohol, yes. Drug, I'm not sure. I know before he was with me, I had heard about a drug problem, but as far as when we were together, it was just alcohol.
And what is his issue with alcohol?
He is just constantly drinking and does not know how to stop, and gets more angry and violent when he is drunk as well as when he's sober.
Does he drink around the children when you were together, or did he?
Yes.
Do you know where he's currently living?
I do not.
Do you know where he's currently working?
I do not.
Has he told you about his income recently?
Yes, he told me that he makes $15 an hour, but that's the only thing he's told me as far as income.
When did he tell you that?
It was a few weeks ago.
So like in the month of October, he told you he made 15 an hour?
Yes, in October.
Did he tell you that he works at least 40 hours a week, making
Yes.
that 15 an hour?
Yes, he told me that he works Monday through Friday from 5 a.m. to 9 p.m. and that is why he does not see the boys.
Did he also tell you that he works on the weekends?
Yes, he said he works all day, every day on the weekends, that he has his own side business.
Did he tell you how much he makes at that job?
He did not.
Are you asking the court to appoint you sole managing conservator of both of your sons, Landon and Lane,
I am.
with exclusive decision-making rights for their care?
Yes.
Are you asking the court to order that Mr. Elias have supervised visitation at a facility, either kid share or guardian house, at his
Yeah.
sole cost?
Yes, I am.
Do you believe that supervised visitation is in your children's best interest?
Yes, absolutely.
Do you have concerns about their well-being outside if he were to have unsupervised visitation?
All right, and Ms. Jamison, I've heard enough to,
Okay.
if that's correct. Let me ask Ms. Reed, do you have any questions for this witness?
Yes, sir. Ma'am, how are the children currently receiving their medical insurance?
They're on Medicaid.
Okay. And at or near the time of the birth of the children, did you and Mr. Elias sign the acknowledgments of paternity saying that he's the father of the kids?
Yes.
And does he appear as the father on the children's birth certificates?
Yes, ma'am.
I have no further questions for this witness.
Ms. Jamison, how long do you work on an order?
I do have an order prepared. I have a few edits to make that shouldn't take me very long, so I can circulate that with the Office of the Attorney General if that's okay with the court.
All right, that's fine. You can either submit that with the e-file system, or if you get it done while we're still going in court, if you just want to stay on the Zoom meeting, you can post that to me in chat and I will sign it and send it to the clerk's office.
Okay, I will do that, Your Honor.
All right, and I'm going to ask Ms. Reed, is that all you have, except possibly talking to Ms. Rivera?
Yes, Your Honor.
All right, so I'm going to ask Norma to put you and Ms. Rivera in a breakout room. All right, and in the Munsler children, what do we need to put online or put on the record?
Yes, Your Honor.
Oh, and let me state before we're still here that the bailiffs did call Jacob Elias outside and there was no reply. They reported that to me. Go ahead. All right, Ms. Tapia, you're ready also?
Yes, Your Honor. We, as Ms. McLaughlin stated, we have an agreement that we would like to put on the record.
All right, go ahead.
Okay. The current orders for custody, visitation, child support will remain in effect until further court order. The parties will register to be examined by Dr. Dina Trevino in San Antonio, Texas, for a child custody evaluation within 15 days of today's date. Mr. Munsler will be notified of all appointments made for the child, Aaron Munsler, as he enters counseling and has a psychological examination for the child. All the parties will, of course, cooperate with all of the necessary appointments and payment of fees. All fees are split 50-50. And then, Your Honor, we would like a date in January, approximately 90 days from today, to set a status hearing, make sure everybody is on track at that point.
That is correct, Your Honor. We have
90 days from now would be February. So do you want 90 days or January?
February is fine.
And we also had agreed that the parties would start communicating using app close.
Yes, correct.
All right, February 1st, there's a 2-week jury block that starts on February the 8th. So February 1st.
That's fine, Your Honor.
That's fine.
Okay, if one of you would send that to me in chat, that just the cause number, style briefly, and 2-1 and what that setting is for, I'd appreciate it. And do we need an entry date for this? Your temporary orders?
Yeah, we can set a date 2 weeks from today, if the court will be in session, and I will prepare the order.
And I can send the reset date for February in chat to you, Your Honor.
Okay.
Thank you.
Okay, what I'll give you the 14th. Now that's technically, I think, Judge Ellison's docket, but if you need to have a hearing, he can just send you over to my meeting. So we'll put 11/24 entry. And 2-1 is the merits?
Yes.
All right, so 11/24 entry, 2-1 merits.
And Your Honor, on a different matter, Mr. Esquivel on a criminal case, he's the number that ends in 553.
All right, let me look. I think that's everything on the civil docket.
Thank you, Judge. May we be excused?
Yes, ma'am. So
thank you.
Judge Wilson, we have received a phone call from Jacob Elias, which is the case that Miss Jameson and Miss Reed had.
Yes.
Checking to see if court was still going on. And I know his case is already done.
Okay.
I don't know if you want us to tell him something that the case is done.
He was at probation.
He's telling us that he was at the probation department.
All right. Ms. Jameson, are you still listening?
I don't see Miss Jameson on. I think Miss Reed went into a breakout room with Miss Rivera.
Yes, no, I still have a box that says Ann Jameson.
Oh,
All right,
there, yeah, I do see the box.
Let me send her a message in chat. All right. I guess tell him to hang around outside,
Okay.
and we'll see if we get him back on. Let me send a message to Ms. Reed. I can't see her because she's in a breakout room, I guess. Okay. All right. Back to the criminal dockets. So Land Davis Rutledge, Ms. De La Garza has appeared, I think.
Hello?
Yes.
I'm sorry, Judge.
Yes, ma'am. Is Mr. Rutledge here?
He should be. I spoke to him this morning. Let me check my phone, and we believe he might be on an unidentified phone number.
No, she wants to take her phone.
But it's, I mean, it's fine.
There he is. There he is.
Okay. All right. There's a phone that says Alexis Pella. Is that Land Rutledge? All right.
Okay.
All right. Let me change the name.
All right.
Okay. I'll mark you conferring.
Okay, Judge, I have an agreement with the prosecutor. We even spoke again this morning. And she is going to send me paperwork so that we can sign it. And we'd like to reset maybe to Monday to do the plea that day.
Yes, sir.
I can't hear.
Okay. You broke up a little bit. You want to be set for Monday? Okay. All right,
We
Ms.
want
De
to
La
be
Garza.
set for Monday to enter the plea, Judge, and or do plea and sentencing. We
That's
have
fine.
an agreement, and we just need to get it sent to us so that he can.
Okay, I understand that. What I'm going to ask you to do is if you will send me in chat a message that has the cause number, just the cause number, you don't have to spell out cause number, the cause number, your client's name, and the date that he's coming back, which is Monday. As soon as you send that to me in chat, you're released. And he'll go on the docket for Monday. My chat is automatically saved, so we have a record of what everyone's doing. Eric Scott Schindler, has he appeared, Mr. Arguez?
You got a reset date, Your Honor, of 1/6.
Okay, I know I was gone for quite a while. All right. All right, and Joshua Esquivel has appeared.
Yes, Your Honor. He's the phone number that ends in 553. Mr. Esquivel, if you could announce that you're present.
Yes, ma'am, I'm here.
All right, thank you. I'll rename you. Jonathan Montoya. Still a no-show. Rutledge is here.
I'm here. Montoya's here.
All right.
Hello.
Yes, okay, Mr. Montoya, your phone ends in 5 or 159.
It's 5560.
All right. All right, we'll check on your attorney. And whose phone number is unmuted? It's 830 and it ends in 159. Okay, whose phone number ends in 159? You keeps unmuting themselves.
Jacob.
Jacob who?
Elias. Elias.
Mr. Elias, where are you?
Sir?
Where are you?
On my way to LaGrange for work.
Okay. All right, now your case was called earlier today and it's been disposed of today. So are you asking to have that recalled and put on testimony, or what are you asking to do?
I was just told I had court this morning, but I had probation as well this morning, so I couldn't make the Zoom meeting. I had probation at 8 o'clock.
All right, sir, my question is, are you asking to try and get the attorneys back into the Zoom meeting and to have a new hearing, or are you just reporting that you're here and on your way?
Just reporting I'm here.
All right, well then you are released. Thank you. All right, Grace Rocha, I believe Mr. Barrera said she appeared.
She got a reset of 1-6, Your Honor.
Okay, Daniel Ramirez.
Judge, he logged on. I told him that you ordered him to report in person, and he was not able to unmute himself, and I think he's since logged off. So I don't know if he's reporting in person or not.
All right, we'll wait for that. Okay, so do we have announcements? Do we have pleas? What's going on the criminal side?
I have a plea. I think you're waiting on a judgment. As soon as that gets there, I'm ready to go when you are.
And then, Your Honor, we had Mr. Chance Bush, who was set for a motion to revoke, who is currently, I guess, in Houston, when he was told to be at the probation office.
Okay, let me see. All right, Mr. Keendaws. Is he back off? He was here a while ago.
I believe, Your Honor, he's bouncing between courts.
Multiple courts? Okay.
Yes, Your Honor.
All right. So I just opened my email back up. Do we have any pleas that are ready to go now?
No, so the only plea that we were going to go forward with today is the James Anthony Gonzalez, and I'm still waiting to get a judgment on that one.
Okay, well, if you'll go ahead and send me the rest of it, we can maybe get started.
Okay, I will send it your way. This was on an MTR, I believe. That is the plea packet. Do you need a copy of the MTR?
I should not. It should be attached, or the violation report. Let's see what we have. Yes, I need the violation report for the state's exhibit, please. All right, so when we get the offense report, or pardon me, the violation report on Gonzalez, we're ready to start. And is the jail online?
Yes, Your Honor.
Wilson inmate, okay. If we could get James Anthony Gonzalez, I'd appreciate it.
Yes.
Judge, I just sent you the violation report in NPR.
I have Mr. Gonzalez, Your Honor.
Thank you. All right, and I received the MTR, and Ms. Sawyers, I'm sorry, what I actually need is the violation report.
And Mark Lede was sending that, Your Honor.
It's connected to the two documents emerged in that one PDF, Judge.
Okay, well, what I received from Ms. Sawyers is just 2 pages. It's just okay, now here's something from Mr. Leday. Okay, I've got them combined. Calling State versus James Anthony Gonzalez. Are both sides ready?
State's ready.
That's ready.
Okay. All right. Are you James Anthony Gonzalez?
Yes, Your Honor.
And are you the same James Anthony Gonzalez who, on or about February the 5th of 2019, all right, how many years probation was this?
What's the question, Judge?
It says that it was an underlying sentence of 2 years. How long was it probated for?
3 years, Judge.
Okay. Were you the same James Anthony Gonzalez who, on or about February 5th, 2019, was given a sentence of 2 years in a state jail facility that was probated for a period of 3 years?
Yes,
So were you
Your
placed
Honor.
on 3 years probation? Yes, okay. All right.
Yes, Your Honor.
The state has alleged that you have violated the terms of your probation. Specifically, they're alleging that you violated rule number 1 of your probation, and that while you were on or about March the 28th of 2020, you were in the 38th Judicial District Treatment Center in Uvalde County, Texas, and that you left the treatment facility without the director of that facility. So do you understand what the state is alleging?
Yes, Your Honor.
Okay. And let me just ask, typically, rule 1 is not to violate a law. Is that rule 1 on this particular probation was to complete the stay in the correctional facility, in the drug treatment facility in Uvalde?
Correct, Judge.
Okay. All right. So you understand, sir, but the plea bargain agreement you have with the state is not binding. I do not have to follow it, but if I decide not to follow it, I will allow you to withdraw your plea. I need you to answer out loud so the court reporter can write it down.
What are you saying?
All right, Mr. Gonzalez, I don't know if you were able to hear me. My question is, do you understand that whatever plea bargain you and your attorney and the state have worked out, I do not have to, but if I decide not to follow it, I will let you withdraw your plea? Do you understand that?
Mr. Gonzalez, it's yes, sir. Everything is yes, sir. I can't hear you.
Yes, Your Honor.
Okay, and were you able to hear the question?
Yes, sir.
Right. Okay. I asked that because your video appears to have frozen.
Yes, sir.
Okay, and would you move around some? All right, let's see if that clears up because again, your video is frozen and we can't see if if you're able to respond or not. Yeah, okay, we're not able to understand. I'm gonna ask the jail to leave the meeting and then sign back in and see if that helps, because the picture's for a couple of minutes. Okay. Okay, you're back. And well, some movement.
Is that better, Your Honor?
No. All right, I tell you what, I'm gonna start going over the docket with the coordinator and with the attorneys for the state. And let me do that for a few minutes. And hopefully it's just that the internet is slow and that it'll speed back up between here and the jail. If not, we're going to have to either delay this or get Mr. Gonzalez over here in person. So let's give me a few minutes. Y'all still appear to be frozen. Hopefully it'll speed back up. Okay, Jacob Flores, we have attorneys for the state and for a minute. All right, Jacob Flores, what's going on?
I did not get any information.
Nor I, Judge.
Okay. And again, I was gone for 20 minutes and I have a text messages I haven't looked at. Bush, we're waiting on Mr. Keendaws. Nicholas Moreno, we have dates? Not yet?
No,
I have
sir.
not got the date yet.
All right. And Ms. De La Garza, are you sending me dates on Land Rutledge?
She stepped away. She said they were supposed to send her to a chat room or something, but it never went anywhere.
She never
Chat room.
requested one.
How did
She's
she request
actually
it?
on the. She's actually on the line with Jennifer now. That she's having issues.
Okay. Okay.
Can you
That's
tell
fine.
me how to do it and I'll try to do it myself? She's not technical savvy.
Well, Norma will just give you one and you should get a pop-up.
Perfect.
Okay. A chat room with who? All right, whatever. No, a chat room with who? Who did she want a chat room with?
That's just what Ms. De La Garza said. I wasn't in the room when that was said.
Okay. All
I
right.
think she was just supposed to post dates, Your Honor.
That's what I thought.
I think
All right.
she's supposed to do the dates.
That's what I thought. Dimitri Ortiz?
I have a reset date of 1/6/21.
Correct.
Thank you.
Fidel Trevino Jr.
Reset date of 1/6/21.
Okay. Diego Mesquita,
Do not have anything yet.
I'm here, Your Honor.
all right.
Your Honor, if I
Yes.
could get a breakout room with Mr. Amosquita, please.
I will give you one, Mr. Briggs.
Thank you.
Cassidy Dunson,
I have 1/6 of 21, Your Honor.
That's correct.
all right, and I see the jail and I see movement. If that continues, in the bottom of the page, we'll try that again. Schindler, 1/6, John Brown.
1/6 as well, Your Honor.
Heather Cruz.
1/6.
Okay, and I'm still seeing movement at the jail, so hopefully we've got a better connection. I'm asking y'all to unmute.
Can you hear us now, Your Honor?
Yes, okay. Mr. Perez, you ready to go?
Yes, sir. I'm ready to go. Mr.
All right.
Gonzalez, everything is yes, sir, no, sir, okay?
Yes, sir.
All right. And Mr. Gonzalez, you understand that I do not have to follow the plea bargain that you have worked out with the state?
Yes, sir. Yes,
So
sir.
if I do not follow it, I will let you withdraw your plea.
Yes, sir.
If I do follow the plea bargain you have worked out with the state, you will not be able to appeal this matter. Do you understand that?
Yes, sir.
All right, I want to show you some documents that appear to have your signature.
Yes, sir.
They're titled Written Waiver and Consent to Stipulation of Testimony, Motion to Revoke or Adjudicate. And let me ask, on page 3, is this your signature? Okay, and we can't hear you.
Yes, sir.
Okay. And do you swear or affirm that everything that appears above your signature is true and correct?
Yes, sir.
Okay, I want to see if you signed in some other places. Plea bargain agreement,
Yes, sir.
waiver of time to file motion for new trial,
Yes, sir.
certification of appeal.
Yes, sir.
All right. Now, did you read these documents yourself or did Mr. Perez read them to you?
Yes, sir.
And did you understand them before you signed them?
Yes, sir.
And are you satisfied with the work that Mr. Perez has done for you?
Yes, sir.
All right, counsel, do you believe your client understands the nature of the rights he's giving up, the stipulations of evidence he's making, and the consequences of his plea bargain?
Yes, sir.
I'll find that you made your waivers of rights and your stipulations of evidence knowingly, intelligently, voluntarily, and I will approve them. And I'll ask you to the allegation that you violated Rule 1 of your probation by leaving the treatment facility in Uvalde County without permission. Is that true or not true?
That is true. Yes, sir.
All right, I'll accept your plea of true, and that's what evidence the state has.
Your Honor, we offer states one and its attachments.
No objections, Your
Without objection, State's Exhibit 1 and its attachments are admitted into evidence. Do both sides rest and close?
Rest and close, Judge.
Yes.
All right, I'll find that the state has substantiated the violation and that a change needs to be made in the disposition on this case. Are both sides ready for sentencing?
State's ready, Judge.
Yes, sir.
Is there a waiver of a pre-sentence investigation report?
Yes, sir.
All right, what is the plea bargain in this case?
Your Honor, it is 10 months state jail, $60 in restitution, $301 in court costs, current fall time served. Mr. Gonzalez has possible time credit in multiple jurisdictions, which is what's slowing up our judgment. We're trying to get that down. I will check with Mr. Perez to make sure that he gets proper credit.
We're fine with that, Your
Okay, would you? Okay, one more time. What is the plea bargain agreement?
It's 10 months state jail, $60 in restitution, $301 in court costs.
Okay. All right. Oh, hold on. Okay. I had a splotch on my screen and it was right on top of the box for 200 hours of community service restitution. And I
He
was
does.
figure out why we were doing CSR on a time case. Okay. Mr. Gonzalez, you heard what was read in the record by the state's attorney. Is that your plea bargain with the state?
Yes, sir.
Okay. Did the state's attorney add anything or leave anything out?
No, sir.
All right. What sort of cases do you have in other jurisdictions?
Oh.
Your Honor, I'll answer to that, Your Honor. The number one here, we pled him out in Uvalde County for that offense. They actually gave him probation over there. I'm going to file a motion to adjudicate over there since he's being revoked here. But from what I understand, he just has the unauthorized absence from the CCF in Uvalde County, which he's technically on probation for right now. Is that correct, Mr. Gonzalez?
Yes, sir.
Yeah.
Okay. How long was Mr. Gonzalez in the facility?
Only a month, I believe. Correct, Mr. Gonzalez?
Yes, yes, sir.
All right, so about a year passed between when he was placed on probation and when he went to the facility. I take it that there were things that occurred during that year that caused him to be placed in the facility a year down the road?
He was in jail in Uvalde for a while. I don't remember exactly how long. I think he was in jail prior to that in San Antonio on these cases. And aside from COVID-19 happening, I'm not sure what else he had going on.
Okay, so I guess because I don't have a PSI, what I'm trying to figure out is this wasn't a case where he was out on probation and compliant for a year and then went to rehab and left, and that violating rehab is the only thing that he did incorrectly in a year's time when he was out on the street. He was either locked up or there was something else going on in the interim.
I believe so, Judge. I'll need Mr. Ledet to answer to that.
I don't have an answer to that, Judge.
Okay.
To the best of my recollection, he was in jail when I first represented him in Wilson County. I got him probation and CCF was part of it, but I can't remember if that is correct, but that's what I want to believe was correct. I believe he was in custody. I represented him. We sent him to CCF. He went, he absconded, and here we are now.
Okay. All right. And how long is it going to take to get an answer on the number of days credit?
Judge, we should have that ready probably within an hour.
Okay, then. I find I have enough evidence to make a decision here without a pre-sentence investigation report. I will follow the plea bargain agreement. I'll sentence the defendant to confinement in the state jail facility plus court cost and restitution. You understand, sir, that with the exception of the number of days you're entitled to credit for, which is still an open issue, that with the exception of that, because I have followed the plea bargain agreement in this case, that you've waived the right to appeal?
Yes, sir. Yes, sir.
Right. Okay, then I will post-trial waivers knowingly, intelligently, and voluntarily, and I will approve them. I will certify to the Court of Appeals that you've waived the right to appeal and you may not appeal. I'm going to ask the Sheriff's Department to go ahead and get a thumbprint, and you can return to your cell, but we will, I'll ask Mr. Perez to hold on for a while so we can verify the dates.
Yes, sir.
And how many days does Mr. Gonzalez think he's entitled to, or he's not certain?
He's not certain, sir. I'll have to talk with Mr. Ledet, and I already told Mr. Gonzalez that if the days are wrong, and I'll make sure that it gets correct, but I'll hang on.
All right, thank you. Okay. All right. Ms. Taylor Garza, yes, you are excused. Thank you.
Also, Judge, if you could have Daniel Ramirez called, he was online. You ordered him in person. I don't see him there now, so he might be in the courtroom the way you requested.
Okay, Daniel Ramirez, yes, thank you. Okay, yes, Sergeant. So is calling that. Okay. All right, so we have anything else ready to go?
Your Honor, a couple of things. A case that's not on the docket, Hawkins, he has a nice eye. He was supposed to turn himself in on Tuesday for ISF. He's turned himself in, and I'd like to ask you to remove the nice eye so that he can be sent to ISF.
All right, well, this is Tuesday, so he was supposed to turn himself in last Tuesday is what you're saying?
Sorry. Maybe probation can clarify that with me. They contacted me this morning. I think was it last Tuesday? And this would be Atascosa County. I don't know if they're on.
Oh, no, they're not on.
All right, let me contact them because they're the ones who contacted me. And the other one, I'm here for a habeas on Jacob Trevino. I would just like to confer with him briefly before we go forward with that.
And Judge, just on that habeas, we've checked. We saw that it was put on the additions yesterday. I don't know if we've ever been served with it.
It's served automatically. I believe it's, let me double check.
All right, Ms. Jameson, are you available?
Yes, Your Honor.
Okay. All right, I have Adobe Acrobat. I have it set up with the little stamp signature that's not verified. I also have it set up with the digital signature that is verified. But it says that you have defined where I can sign things. It's not letting me sign this.
Okay, let me print it out and rescan it in, and then that should work.
Okay, no, I can just print it to a PDF. I just didn't know if there was some secret command I had to give it to allow me to put a digital signature on her.
I think it's because I use DocuSign, and those are considered secure, and so it's probably just because I downloaded it straight from that program. So maybe if I print it and rescan it in, that issue.
Okay, no, that's not a. I'll just print it to a PDF and it won't be a problem. I didn't know if there was something I needed to do to enable me to sign it.
I think it's just the DocuSign acts funky once you try to sign it on Adobe afterwards. So that's probably my error. Do you want me to resend it to you, Your Honor?
No, I'm about to sign it. I just. And Mr. Elias appeared while you were gone.
Oh, okay.
He said he had probation this morning, and that's why he couldn't be here at 9 o'clock. Now, his probation was at 8, so I'm not sure why he couldn't have made it by 9. But he said he was on his.
Serve him on September 22nd. So he had the information and got served with everything that was set for today.
He called in and he said that he was on his way to LaGrange, and I asked if he was just telling me that he was on his way to LaGrange or if he wanted me to get the attorneys back and redo the hearing, and he said he was just telling me that he was on his way to LaGrange. So I said, okay.
Okay.
So just to let you know, that's what happened.
Thank you, Your Honor.
All right, Your Honor. Normally, it doesn't allow me to send or file something without sending it to Mr. Lede, but this time I guess he did not receive service. Maybe I can speak with him about an agreed habeas if I can be put in a room with him.
Okay, Norma's in charge of that, and I just posted the signed SAPSR and the Elias children. You ought to be able to get a copy of it, and I'll ask Ms. Kruger to get a copy.
And Judge, I just forwarded the judgment for James Anthony Gonzalez to Ms. Sawers. He has 112 days of credit.
Okay. What? What about him? Okay, thank you. All right, Mr. Perez, Daniel Ramirez is here.
Very good. Judge, on this case, we've not been able to get a waiver of arraignment from him. I mailed it to him. He told me he completed it and mailed it back. We reset him about 2-3 times to try to see if it came in. It never came in. Last time he was scheduled for court by Zoom, he did not show, and you ordered it to be reset today. I'd ask that he signs the waiver of arraignment right there in court while he's there. And then I'd like to go ahead and set his case for trial just as soon as we can.
Okay, is the clerk's office able to get a copy of that form to him so that it can be a
Yes, sir. I can have him sign a waiver of arraignment. What day do you want me to put on it? Court date.
Ask Norma.
Norma gave me 1-6 on the other ones. If you're okay with that.
That is correct.
That's fine.
Okay.
Okay, I will get the form to him right now.
After he signs that, Judge, maybe he be excused, and then I'll call Mr. Ramirez and we'll get in my office and we'll go from there.
Yes.
Okay, Mr. Ramirez, after you're done there signing the paper, you're good to go. Give me a call later, okay?
Okay, yes, sir. Thank you.
Thank you. Judge may be excused.
And were you content with 112 days? Is that Mr. Gonzalez was still in?
Honestly, Judge, I have no idea how much time Mr. Gonzalez thinks he has. With your permission, I'll send him. I still have to deal with him for the Uvalde County case. I'll send him a letter saying it's 112
All right.
days. If he
He's
thinks
still
it's
right there.
wrong,
He's still right here. I said you could go
okay.
back, take him back, but they didn't. So did you want a breakout room, or Mr. Gonzalez is 112 days sound correct to you?
How much is that? That's like 4 months.
About 4 months.
Yes, sir.
Okay.
Okay, then I'll sign the
What
order
else?
as soon as it gets to me.
What are some other options?
There's no other options, James. They're just making sure that that's your back time. They're saying that you have 112 days credit on this case. The judge is asking you if that sounds correct or not.
Yes, sir.
Okay.
All right, then I will sign the order when it comes to me. Thank you.
Okay. Thank you, Judge. May I be excused?
Yes.
Well, this,
Thank you. James, I'll be in touch.
All right, so do we have any other pleas?
Your Honor, I received the order. May I be excused?
Yes, ma'am.
Okay, thank you.
And let me ask Norma, Ms. Rivera and Ms. Reed still in the breakout room, or?
No, sir, they're not.
Oh, here's Ms. Rivera. All right, Ms. Rivera, what did you find out with Assistant Attorney General?
She
Oh, and
basically
they're
gave,
both online, okay.
okay, perfect. Ask Ms. Reed.
Yes, they're still here.
Thank you, Ms. Reed.
I calculated based on the numbers that she gave me as his income. Child support or guideline would be in the amount of $509 for 2 children. And the government medical support would be $113.
Okay.
And that's based on $2,500 a month of income for the father.
All right. Okay, and let me look at the proposed decree.
Thank you, Ms. Reed.
All right, and Mr. let me ask you, what paragraph does the reimbursement of $113, do you know offhand what paragraph that is, or?
Normally there's when there's options, with no one has medical, there's a thing for mom to apply for government medical.
Yes,
Then
it's right
dad
here.
would pay $113.
Okay. And do you want me to get this scanned in and give you an opportunity to look at it?
Yes, please.
Okay, I will initial these changes. I'll make these changes, and then I'm going to ask the clerk's office to scan it because it was just handed over by Ms. Rivera. All right, Ms. Rivera, the last thing I have is I have not gone and looked at the property yet. What I need to tell you is that the law in Texas presumes that every single thing a married person owns is community property. And it's not a matter of whether you and your husband have an agreement or don't have an agreement about any property. The divorce decree needs to spell out what happens to it, if it's going to whoever it's going to go to. And what happens is that if you don't do that, and the law presumes that I, the judge, forgot to divide your community property and that you still own it together even though you're divorced. And years from now, if your husband, whose ex-husband then doesn't pay his taxes, or he gets into a car wreck with no insurance, his creditors can come after you and claim that he owns half of something that was owned during the marriage. So what I need to ask you is there anything that needs to be listed? Any real estate, any automobiles, boats, horses, retirement from anywhere other than Social Security?
No, Your Honor.
All right, so that's 509 and it'll go down to $387 if we round it to the dollar for one child?
To $407.
407, okay. And you're asking to have a previous name restored, ma'am?
Yes, Your Honor, please. My maiden name.
Okay.
Solis, Solis.
All right, and okay, all right, I'm going to ask the clerk's office. I'll find I have jurisdiction to hear this matter. It's been on file for more than 60 days. And ma'am, were you a resident of Wilson County for 90 days in Texas for 6 months before this lawsuit was filed?
Yes, Your Honor.
And the petitioner met the residency requirements. There's a waiver of citation in the proper format on file.
Yes, Your Honor.
And it's been on file for more than 10 days. I'll find that marriage has become undermined due to a discord or conflict of personalities, and I'll grant the divorce in open court. There were 2 children born to the marriage who have not reached 18 years of age, and I'll find the orders are in the best interest of the children and approve them, and I will set child support at the guideline amount, and also reimbursement for healthcare insurance and government aid. I'll find the proposed division of the marital property and debts is just, fair, and equitable, and I will approve it, and I will restore the petitioner's maiden name.
Thank you, Your Honor.
And let me ask Ms. Reed, I'll SMS the clerk to send this to you for you to look at before I sign it. And will you or your office do a withholding order?
Yes, Your Honor. I will basically, we do have an open case right now. It is still in our initiation phase. So I will email management and let them know what we did today so that we can get it assigned to our office and we can do that.
Okay, excellent. Thank you. Then both of you are excused.
Thank you, Your Honor. Have a good day.
Thank you.
Thank you, Ms. Reed.
Thank you.
Okay, judgment.
Hi, Judge. Just want to let the court know that Miss Cindy called me and let me know that my client logged on, Jonathan Ryan Montoya, to the Zoom call.
All right, give me just a moment.
Yes, Judge.
And Norma, can I be put in a breakout room with the jail and get Mr. Jacob Trevino?
And
Yes,
what
sir.
county jail is he in?
Wilson.
Okay.
Breakout room number 10.
Thank you. And I believe, so you're regarding Mr. Zamora or Mr. Hawkins, Jamie Hawkins, he was supposed to turn himself in on Tuesday. Apparently he turned himself in on Wednesday, and he's been in jail since then. So they've been holding him, and we're just asking to remove the NISI to ship him off to ISF. I've asked the probation to join, so they may be getting on shortly.
All right, well, let's give them a moment to do that.
All right.
All right, I just posted the signed judgment in Gonzalez, I hope, yes. And had I posted the waivers in Gonzalez already? I don't know what I had. There are those. Okay. All right, so do we have any other pleas? What's going on?
Could I be placed into a breakout room, Mr. Montoya, Your Honor?
Norma's in charge of that. She's
okay. Yes, sir.
Your Honor, I don't believe we have any more pleas, but I do believe Mr. Doss is back in regards to Chance Bush.
All right.
That is correct.
Okay, so what's supposed to be happening with Mr. Bush today?
Your Honor, he was set for a motion to revoke today. He was told by probation in person on November 3rd that he needed to be at report to probation this morning, and he was also sent a reminder. Is my understanding that he called them this morning to tell him he wouldn't be there because he was working in Houston today.
And I'm on my way back.
And Judge, there seemed to have been a mix-up. So I am asking on behalf of my client if we could just set this for when the MTRs are set. I think it's December 7th. We do have an offer from the state. So, I guess kind of just give him this chance.
And Your Honor, if the court is inclined to let him report, we would ask then that he report on Monday and that we have this motion to revoke heard.
Okay, I could agree with that.
All right, give me a moment. All right, now I have oh, this is from last year, never mind. Okay. All right. Mr. Bush, you understand that you need to be here at probation in person on Monday at 9 a.m.?
Yes, sir.
Okay. All right. Well, I'm a little surprised at what the state's agreeing to, but that's fine. I just searched your, and I saw where and that's great. I mean, it's my job to say no sometimes. And I was concerned, but then I saw that some of the dockets I was looking at were from last year, before you were actually adjudicated in this case. So I'll set the motion to revoke in both your cases at 9 a.m. On what day is Monday?
The 16th, Your Honor.
So you're set for 11/16. We'll see you then.
All right.
Your Honor, we will request you still report to our office today.
What's that?
We still request you report to our office today.
Okay, that's fine.
Okay, you understand that, Chance?
Yes, sir. I heard him.
Okay, so you got to go down there today, okay?
10-4.
All right.
All right, was that one case or two?
That is just one case, Your Honor.
Yes,
Okay.
one MTR.
All right.
Your Honor, we have Brandy Gibbons here. Mr. King Dawes has posted a date. Can Brandy Gibbons leave?
Yes.
I was told that the next dates were January 6th for pretrial or another.
Yes. Yes.
Okay. I had posted that.
Yes, I got it. That's fine. Okay, so Jacob Flores, what's going on with him?
Your Honor, I have nothing, and Mr. Ernst was on earlier, but I haven't heard nothing since Mr. Ernst made the announcement.
Okay. Did he post in your private chat and not to the full group?
He may have, because I was gone for 20 or 30 minutes, and then whenever I left, I've got that in two different places. So I've got two chats going on, one from earlier and one from now. So we'll check on that in a bit. I'm just wanting to see where we stand. Okay, on Mr. Rutledge, he has 11/16.
Yes, Your Honor, two plea.
Nicholas Moreno
has 1/6, Your Honor.
Mesquita, Mr. Briggs, are you still conferring?
Judge, actually, we've reached an agreement with that. I would like to set that for a plea on Monday, if at all possible.
11/16 plea. Okay, the rest of the page is 1-6. Justin Daniels,
1-6, Your Honor.
All of this next page is 1-6, Your Honor.
That is correct.
I feel old when I see a guy I prosecuted as a juvenile is going to be 40 next year. Mr. Daniel. All right. Mr. Mathewson, did we find out if he was in treatment?
I have not heard anything, Your Honor.
I'll put no show, but we'll check on that. All right, Jonathan Montoya, he showed up, I think.
He is in a breakout room with Mr. Arguelles, Your Honor.
Right.
And Your Honor, we have a agreed, the state has agreed to a PR bond in Mr. Trevino's case. And I believe you have an order prepared to be signed.
All right, let me finish going through this. Nicholas Moreno, Mr. King does.
He received dates of 1-6, Your Honor.
All right,
The rest of the page is 1-6.
okay. Christopher Rodriguez,
1-6, Your Honor.
sweat spell,
Is 11-16 to pay, Your Honor.
De La Cerda,
Is 1-6.
Saunders,
Is 1-6, Your Honor.
okay, Rocha and Diaz are 1-6. Trainer,
Is 1-6, Your Honor.
Ramos.
At 1-6.
All right, remind me to be sick that day. Ramirez is 1-6. Actually, has he signed that? I haven't seen it. On Daniel Ramirez, he was supposed to sign the waiver of arraignment and accept that date?
Yes, sir. I do have the form here in the office. He did sign it.
Excellent. Pedroza, 12-9.
Yes, sir.
All right. So is that everything on the criminal side?
That is everything.
Report back. Okay. All right. Mr. Arguelles, did you have something?
Yes, Judge. I want to see if it was possible I could confer with somebody from the state. We could potentially resolve this case.
Okay.
If Ms. Whitney's available or Mr. Lede.
I'm available.
I'll put you in breakout room number 14.
Thank you, Norma.
Yes, sir.
And was there a motion to revoke the bond on Gloria Pinchorn?
We are waiting on for some information, Your Honor. We may be filing one, but we have not filed it yet.
Lydia, I think that's all that you have until 1 o'clock. We've got Peeler at 1 o'clock. Mr. Nitz, you said you're sending me an order.
No, I believe I've already submitted. I can resubmit it over the chat, but I've submitted it through the proposed order.
Okay, and what county is that in?
Wilson.
It's a habeas, Judge. We've agreed to it.
Oh, no, you know, I think they rejected the order because it had a setting order attached to it. So let me send you the, let me send.
Just post that in chat while online, because that's just 2 additional steps going through the clerk and the coordinator and making work for them.
Okay, I'll do that.
Judge, in chat, I sent the Rivera divorce. Ms. Reed did sign off on it.
Okay, I will.
Hi, Judge. After confirming with Ms. Whitney, I wanted to ask the court if it would be possible we could come back sooner on 11/24, if that's okay with the court on this case on Mr. Montoya's.
Sure.
Okay, I'll put it in the group chat and then I'm going to go back in there and explain that to him and then if we could be excused.
Okay, you're excused after that.
Thank you.
Okay, Ms. Kruger, I just sent you the signed decree.
Okay, I see it. Thank you.
Okay, and what's going on Jacob Trevino?
Your Honor, I sent the order via chat.
So it's, okay, but what is the agreement for?
Agreed PR bond.
And what's he charged with?
Credit card, debit card abuse, Judge.
It's a PR bond. I'll make it a $10,000 PR bond.
Your Honor, I believe it's currently set at 7,500. I'm just requesting that it be continued at that amount, just in case.
Okay. All right. Ms. Kruger, all the attorneys, I just posted that back.
Thank you. Mr. Trevino, when you get out, make sure you contact me so I have good contact information for you. All right?
Okay, so we're waiting on Mr. Arguelles to confirm?
Correct.
Okay.
And may I be excused?
Yes, sir.
Oh.
That's all you have.
I believe Mr. Lamb is preparing a withdrawal of the NISI form, so we'll address that at another time.
Okay, that's fine.
Thank you.
Okay, in the Wilson County Judge's queue is empty for right now.
Thank you, Your Honor. May we be excused?
Yes, I don't think we need to jail anymore. Yes, thank you for signing back on.
Thank you, sir.
Your Honor, I'm on hold with Mr. Fiegel's office.
Right.
Trying to find out about Cameron Mathewson.
Thank you.
Okay, Your Honor, Mr. Fiegel sends his apologies. It was just an oversight. He missed the invite, but he says Mr. Mathewson is still in treatment facility. He doesn't expect him to be there but a couple more weeks, and so he asked if we could set it in December for a status hearing date. I gave him some possible dates, and he is requesting 12/9.
All right. 12/9. Per attorney on phone. Okay, excellent.
Your Honor, on Jacob Flores, we telephone call Mr. Ernst, and he did say that he posted to chat 1/4 of 21 for pretrial.
One four?
Yes, sir, that is correct.
That is a Wilson County date.
Okay. Thank you.
Judge, I believe that resolves all the criminal cases. May we be excused?
Yes, what happened with Mr. Arguelles' case?
I believe.
Mr. Jonathan Montoya, he got 11/24, Your Honor.
Okay, I'm sorry. $11.24. Okay. All right, then. Excused, except for Buddy, and you're excused until 1 o'clock, or she's already gone. Shay. All right, Shay. I'm sorry. You're excused until 1. Cool. And Ms. Sawyer's, you're excused. That's a case.
Thank you, Judge.
Your Honor, did you want me to log back in at 1, or you just want to give me dates?
Well, there won't be any dates. That's just interminable hearing on
Okay.
their press. They had 18 of them, and I've heard about 6 so far, I think.
Yes, sir.
So, no, I'll be here.
Okay. So let me know if you need anything.
You don't need to be here. No, that's fine. I'll wait until. Actually, you're still the host, right?
Yes, sir.
Okay. Let me leave, and that will. No, that'll make it too complicated. I was going to leave and just send you everything now. I'll wait until I'm finished with Peeler, and then I will send you the dockets and the chat all at once. Because if I leave now, then there's going to be 3 chats, and if something else happens, 2 is already too many. So, all right, thank you.
Okay. Okay. Thank you.
Judge,
Yes.
so you want me to just stay on Zoom?
You can sign off. I don't care. I'm going to leave it on. But yeah, just be back at 1 for the motions to suppress.
Okay,
All right. Thank you, ma'am.
all righty. See you then.
This is Judge Wilson. Is there anybody there that could send me a Dropbox link with the documents I need to look at today?
Hi, Judge. This is Margaret Peloso. Let me follow up with Jennifer and see. I thought that was already posted for you, but I'll double check. Your Honor, I'm going to chat you the link right now for the Dropbox.
Thank you.
Please let me, oh, hang on, that was not it. I'm sorry. That didn't copyright. That's yesterday's hearing in case you want to watch it again in all its glory. Here we go. That's the Dropbox for today.
Thank you.
Your Honor, did you also want the link from yesterday's proceedings as well, since I know we have a little bit of time left on Verschleica?
No, I download everything and save it.
Okay, wonderful.
All right, are we missing anyone? So is that everybody we need to get started?
The peelers are not missing anyone, Your Honor.
Kiewit Mining Group isn't missing one, Your Honor.
Dan Miguel's all here, Judge.
Beck is all here, Your Honor.
Okay. All right, and did either side have anything brief from the end of yesterday?
Yes, Your Honor. Kiewit Mining Group would like an opportunity, since it was a joint motion, to provide an argument, or I'm sorry, a joint response, to provide a response to the motion to exclude Dr. Verslychek.
And the peelers also have a short response, Your Honor.
All right. Go ahead.
And, Your Honor, I did want to point out one other kind of a ancillary kind of item that before I forget again, I forgot to mention it yesterday. And I think this is something that Kiewit Mining Group and the peelers have an agreement on. The recent order, the amended order related to Carl Killian and the motion to exclude.
Right.
We believe there might be an additional clarification that's needed because Kiewit Mining Group was on the property on January 2011 and not January 2012, as the order mentions.
All right. If you'll send me a message about that in chat, to send it to everyone, I will have a second amended order on that.
Your Honor, we also had a question about the stack motion for summary judgment on the contracts. It was still a little unclear whether the peelers maintain any breach of contract claims under the buffer zone lease. And that's just the clarification we seek.
Right. If you'll send me a text message, not a text, but a chat message, just send a chat message to everyone. I have no court tomorrow, and I plan to sit here and do all these motions. I can catch up on those too and start on some other things.
And then the third issue we all wanted to raise, Your Honor, is whether or not we need an additional docket call and pretrial hearing date. We have one set for February 3rd, and previously the court had thought we needed two, and we don't have one under the current docket control order. And I guess inherent is in that question is, are we really going to have a jury trial in March? And then if we are, should we set a second pretrial motion date?
Well, I know everyone wants to get this done. I will be I can give you well, we can probably do it anytime. When would be a good day? What day in February is it?
It's currently February 3rd, and I think the parties were wondering if that should be moved closer to trial, and then also if there should be two dates. And I'll let others speak, but that was kind of, I think, our conversation about it.
Okay, what opinions do we have?
Your Honor, we think it makes sense to have a second day of pretrial, just to avoid wasting a jury's time once we get started.
All right, and when is it set for jury selection?
March 5th, Your Honor.
Oh.
March 5th for jury selection, Your Honor, and then the trial was set to begin on the 8th.
Okay. All right, so should we back that up, say a week, which would be February 26th? And then a month from that, which would be the January 29th. Is the 26th too far out?
You're talking about January 26th, Judge?
February 26th for one pretrial, the one closest to jury selection. That's a week before, that's a week out. And then January 29th, that's a week, a month prior to the second pretrial.
Sounds good to me, Judge.
So does that mean we would not have the current February 3rd docket call date?
Yes.
Okay.
Okay.
So January 29th and February 26th?
Yes.
Okay. Would you like us to send you an amended order?
Please. Those are both Fridays, so you'll probably be the only thing set those days. I expect you'll have enough.
And Your Honor, just to follow up on Ms. Whittle's question, does the court have any sense as to what the docket's going to look like and whether it's realistic that we're going to go to trial March 8th?
I mean, on the civil side, we can have y'all go. It's kind of up to the Texas Supreme Court. On the criminal side, there's a huge number of things stacked up. Some people really want trials, some don't. But my plan is not to compel people to have a, I don't want to be the guinea pig for compelling people to do a jury trial with COVID rules. I'll let somebody else do that and try that up in Court of Criminal Appeals. At this point, we don't have anyone stomping their feet and saying, my client's in custody, he wants a jury trial or she wants a jury trial regardless of the COVID rules. So we'll see if that changes. We'll see what the Texas Supreme Court does. The rumor is that somewhere after Thanksgiving, they'll come out with an order which may or may not relax the rules after this year. Hopefully.
Okay.
All right. And how is Verslacke, how is that pronounced?
It's pronounced Verslacke.
Verslacke. Okay.
And please forgive me, Your Honor, if I mispronounced that a couple times during my argument. I apologize if I do.
You pronounced it that way, and I had not, and other people had pronounced it different ways. Okay. All right, so go ahead, Mr. Schneider.
Thank you, Your Honor. Your Honor, I just want to take a step back and just talk about big picture. What we're talking about here is the peelers have alleged contamination. Contamination as a base for most of their causes of action and claims in this lawsuit. Certainly all of their claims and causes of action against my client, Kiewit Mining Group. So the question that the jury will decide is whether there is any contamination on the peeler property and whether the peelers were harmed by the alleged contamination. And Dr. Verslacke's opinions are about whether the peelers have shown their property was contaminated. That's the nuts and bolts of it. Specifically, Dr. Verslacke opinions are offered to show that the peelers experts and their theories about alleged contamination is in part missing a step. He's offering a rebuttal to the peelers' opinion and opinions by their experts. And I'll just quickly show the court his designation to show that. Dr. Verslacke's designation is testifying regarding the ecological impacts and the significance and the exceedances by the defendant / counterplaintiff's experts. That's the peelers in this case, Your Honor. And the methods and locations and guidance and values used by the peelers experts in evaluating soil salinity. And then he also provides opinions about the applicable regulatory standards for the background concentrations for the relevant metals. And in addition, Your Honor, he makes it clear in his report that he's offering these opinions as asked by the defendants in this case, in this situation, San Miguel and the others, is to evaluate the scientific merit of the opinions to the alleged contamination and the ecological risk at the peeler property with respect to Mr. Johnson and Mr. Brown. That is what he's doing here, Your Honor. He's just talking about whether they had properly reached the conclusion that there was contamination on the property. And how Dr. Verslacke does that, in part, is by noting the peelers experts did not complete an ecological risk assessment to reach their contamination conclusions in this case. And although I understand that the peelers take issue with Dr. Verslacke's opinions because he didn't also evaluate San Miguel's experts' evaluations or any other experts other than theirs, and he's allegedly applying this double standard. First off, that's not what he was designated to do. He wasn't designated to bolster the testimony or opinions of San Miguel's other experts. Instead, he was to evaluate the opinions of the peeler's experts who concluded there was contamination on their property. And second, if there is any issue with what Dr. Verslyka didn't do with respect to San Miguel's experts or their alleged double standard, that's a basis for cross-examination. That can be done in cross-examination. That's not a basis to wholly exclude his testimony. But let's go back to the heart of the current matter with the motion to exclude Dr. Verslyka. In essence, the peelers take issue with Dr. Verslyka's conclusions in part that the peelers cannot find that there is contamination on the property because they didn't complete the ecological risk assessment. They in general take issue with the methodology he used, and not that he necessarily applied that methodology wrong or he's not qualified to provide an opinion on ecological risk assessments. He's clearly qualified to provide that opinion. And Your Honor, the ecological risk assessment that we talked about yesterday, I'll just briefly go over this again, is it's a well-established scientific technique to look at the impacts of stressors on plants and animals to show contamination. And it can be used before and after the alleged contamination. And let's talk about that real quick. We'll go to the actual expert's report, who actually provides in his report, Your Honor, and I'll share it again. In his report, beginning on page 17, he provides an overview of what an ecological risk assessment is. He says it's a fundamental concept. It's basically, I'm sorry, the ecological risk assessment is a science of evaluating the likelihood of adverse ecological effects to occur. And he says a fundamental concept right here to the ecological risk assessment is the adverse effect can only apply when the ecological receptors, plants and animals, Your Honor, are exposed long enough and at a sufficient intensity. And he states, this follows from the basic scientific principle that all chemicals can be safe or harmful depending on the exposure level or dose. That's what we're talking about here, is whether there was an exposure level enough or dose enough at issue to show that there was actual contamination. You can't simply just claim that there was a chemical of concern and at one point and vis-a-vis its contamination. You have to do more of that. You have to have a scientific, reliable methodology to show that that alleged chemical of concern did some harm. And one of the methods to do that is this ecological risk assessment. And I want to point out, Your Honor, it wasn't, this ecological risk assessment doesn't just go towards salamanders or songbirds, as the peelers asserted here. It goes towards plant life. It goes towards animals. And there is certainly allegations in this case of alleged harm to plant life, vegetation, animals, Your Honor. And I just want to point out the peelers' pleadings in this scenario point directly to that. This is their third amended counter petition. And if we just go through, they make allegations. And I won't read it all the way through, but they're basically saying the alleged discharges, the seepage, are killing vegetation and potentially harming fish and other wildlife. And this goes on throughout their pleadings. They again here, they're claiming vegetation loss as a result of water seepage and other types of animals that are harmed. And again, Your Honor, they in their very damage models, they say damages for the intrinsic value of trees and plants that died or have been distressed. Clearly, ecological risk, ecological alleged harm is at issue in this case, as alleged by the peelers. So it's without merit to claim that someone with the background qualification and the opinions of Dr. Verslyka isn't going to provide relevant opinions here. And as we heard just yesterday during the peelers argument, and this was during the actual McKinney argument, the peelers allegedly pulled out their cattle off their property because there was alleged contamination, i.e. they don't believe that their cattle can safely graze there. And Dr. Verslika's expertise would go directly to be relevant to determine whether the conditions on the ranch pose any risk for cattle grazing. These are issues that are at the heart of the peelers' claims. So if the peelers are going to claim their property is contaminated, and this alleged contamination is causing harm to their property, their vegetation, their trees, and animals, they have to prove that contamination, and they have to show that alleged harm from the contamination through a reliable scientific methodology, like an ecological risk assessment. However, that's not what we heard yesterday during the peelers argument. During the peelers argument, essentially what we heard is the peelers don't have to show any alleged chemicals of concern on their property exceeding any type of ecological risk, i.e. harm to the animals or plants of the property itself, in order to show contamination. We've been in this case for over 2 years, and we heard for the first time yesterday that this alleged contamination doesn't have to show some type of exceedance for a scientific background or a scientific risk assessment, and Your Honor, any regulatory levels. And Dr. Verslika's opinions are offered in this case to contradict those arguments. And that's why the peelers want it excluded, because his opinions basically reveal that the emperor is not dressed. The peelers experts offer opinions about exceedances of background concentrations or visual observations. But Dr. Verslika points out that that's not enough. That's just one step in the process. So essentially, Dr. Verslika is pointing out that the emperor might have been partially dressed. He just forgot to put on his pants, so he's not ready to go outside. And the peelers experts did not follow through, did not complete that proper scientific process, therefore to reach the conclusion that their property was contaminated and harmed by this alleged contamination. That's all Dr. Verslika is doing in this case. And I also want to address an argument or assertion made in the peelers' response, or I'm sorry, their motion to exclude as well as their reply, that there aren't any claims or defenses that turn on whether there's harm to the peeler property or an exceedance to a regulatory threshold. As this court is well aware, due to recent briefing and a good amount of briefing, and with a good amount of briefing to go, there are claims and defenses tied to whether there are exceedances of regulatory thresholds and state action levels. And Cnty Mining Group is not asking this court to adopt or create a revolutionary legal theory in this sense. It's simply asking the court to follow the controlling precedent from the San Antonio Court of Appeals that in order to succeed in their tort and statutory tort claims based on alleged contamination to real property, they have to demonstrate that the alleged contamination exceeded these regulatory thresholds as established by Taco Cabana versus Exxon, as followed by the I will call it the Easy Mart store cases. And I want to point out to the court, again, the peelers continuously point to forest oil. And I will impede the court, I will plead with the court to just read that case. That case is not about overruling Taco Cabana or superseding it. It didn't even discuss state action levels. What that case was about was whether the Railroad Commission had primary or exclusive jurisdiction. And that's not the issue currently before the court. I'll even show the court just right here. The very opinion itself, Your Honor, at the beginning of the opinion, it says the principal question in this case is whether the Railroad Commission, which regulates oil and gas operations, has exclusive or primary jurisdiction over claims for environmental contamination. It wasn't addressing the issue relating to state action levels or Taco Cabana or the precedent held by the San Antonio Court of Appeals, Your Honor. It simply wasn't overruling that. And the reason I'm bringing that up is because Dr. Verslika uses these threshold levels as part of his opinions. He points out as part of his opinions that some of the soil sampling that was done in these alleged exceedances did not go beyond the statewide mediums that were developed by the TCEQ as part of these state regulatory levels. And as we saw from yesterday during one of the arguments, is Johnson, for example, one of the peelers experts, provides this map of all of these alleged chemicals of concern on the peeler's property that are trace levels on. And Dr. Verslika provides an opinion on that. And he basically says that those don't exceed the median levels by this regulatory standard right here. Stuff like boron, arsenic, it's all listed right here for the median levels. That is what his opinions go to the heart to. So again, his opinions are clearly relevant in this case. They're at issue. And again, I'm just going to reinforce to the court that we're not asking for a revolutionary decision here. We're just asking for the court to follow the controlling precedent. And we're just asking the court to allow Dr. Verslika to provide his opinions to the jury concerning the peeler's experts' opinions and conclusions about contamination to show that the emperor is just not fully dressed. This is not raised to the level of contamination needed to move forward with claims in this case, Your Honor. And that's all that we're asking.
Ms. Whittle?
Yes, Your Honor. An ecological risk assessment is not another way of defining contamination. It is instead a tool for a regulator to evaluate the probability of harm from a specific chemical or other stressor. And it necessarily includes value judgments by a regulator, accepting that a certain number of ecological receptors will die or suffer non-lethal impacts from that chemical or other stressor. The peelers, as private landowners, do not have to accept any of that risk. They have common law rights to be free from harm, and they have contractual rights to restore their property to its original state and condition and back to the peelers for their exclusive use. Council showed you a chart yesterday purporting to show the first step of a risk assessment, but I'm not sure where that came from. I looked all around the EPA website on risk yesterday, and I couldn't find that as a description for an ecological risk assessment at all. Instead, Your Honor, I found the following, which I will show you. This is the EPA publication on risk assessment, which is available on the government website. And I have placed in chat EPA's website on risk that explains what this is all about. Here, Your Honor, is the actual chart published by EPA that is the process for ecological risk assessment. There are 4 steps: problem formulation, analysis, risk characterization, and risk management. And you can see, Your Honor, it relies on a regulator, a risk manager, making decisions between the risk assessor and the risk manager about the risk that is going to be accepted. And again, here at the risk management stage, after the risk is characterized, there's a discussion between the risk assessor and the risk manager before they determine how to manage that risk. And that's consistent with what Dr. Verslika testified to. He is a risk assessor who works in tandem and under the oversight of a regulator interested in managing risk. Such regulatory management of risk is patently inapplicable to this case about trespass, negligence, and breach of contract.
Are your clients entitled to on trespass?
So, Your Honor, we believe our clients are entitled to loss of fair market value. This is likely going to turn on whether the cost of cleanup is substantially higher than the loss of fair market value, such that under Texas law, the trespass is deemed permanent because it's not economically feasible to clean it up. So,
okay, you know, do you have to show that there's any problem with the whatever contaminant has trespassed onto their land?
Yes, Your Honor, and we believe we've shown that there's actual property damage, like physical damage, where the soil has disaggregated and no vegetation will grow. And then the groundwater is unquestionably above the limits in the coal ash rule and is required to be cleaned up under the coal ash rule. I expect under the new administration, those laws will get even more stringent, so there's uncertainty inherent in a purchaser of the property taking on that liability for the groundwater cleanup and the soil cleanup that would be necessary for this property. And it, our real estate appraiser.
Okay, but is that what you're talking about? Is that all downstream where you've had liquid discharge? You've had discharges of contaminated water?
So we believe it is for the property where there's been unlawful waste disposal of coal ash. We believe it's for the property that has had discharges of water that has harmed the property. We believe we can show that there are additional constituents. I mean, trespass, I'd ask Your Honor to go back and look at the pattern jury charges for trespass, negligence, and the statutory harm that we're alleging. None of those jury charges require that a jury look at an ecological risk assessment. Instead, what we are supposed to prove under the common law is that there has been an unlawful entry that has harmed the property. And in this case, the damages will likely be the loss of fair market value due to that harm. That's what we have to prove. And so absent from San Miguel or Kiewit's response was any explanation of how an ecological risk assessment can be performed or has any meaning without a regulator overseeing it and making choices about the acceptable probability of harm to a regulator. To the extent that they will agree to limit Dr. Verschlecki's testimony such that he's focused on the specific site investigation techniques that the peelers experts engaged in, like looking at how background was established. That's one thing. But where he is really testifying, which is he repeated over and over, is that the peelers should have done this other esoteric, inapplicable analysis of ecological risk assessment, where there's no regulator overseeing it, making the necessary value judgments. That's where we take issue with it. It's simply irrelevant. And it would go off into a tangent and waste everybody's time. He couldn't even explain how it would be beneficial. Sorry, Your Honor.
How can you show there's damage to your property from a boron on it unless there's some evaluation of how much boron it takes to be a problem?
Well, we have done evaluations of how much boron it would take to kill plants, Your Honor, and that is, and because the boron exceedances are also coextensive with the dead vegetation, we think a jury more likely than not will find that that waste contamination did cause the harm. It's not about a risk of harm, though.
You have?
I'm sorry?
How many acres of dead vegetation are there?
I can't answer that sitting here today, Your Honor. It is quite extensive.
But I mean, I guess what I'm asking is, it's my understanding that there's going to be portions of the Peeler Ranch that have grass growing up on it, and that, from just driving by on the road, a person might not suspect there was any issue with it. I understand if you go by in the springtime when everything should be bright and green and there's big swaths of dead vegetation or bare ground, that yes, you can just drive by and see that's a problem. I'll just say my father had a piece of property right here in Floresville that the fertilizer company had a overflow, and they killed a whole bunch of oak trees, and he had grass wouldn't grow there for years. So, I mean, I understand how that can happen, but are you going to be asking for damages for parts of the Peeler property and ranch that just a drive-by look, you wouldn't think from the eyeball test that there was a problem with it?
Well, there are deed notifications, Your Honor, for the solid waste disposal. I think there's lots of different layers of evidence that we're going to be able to prove has reduced the fair market value of the property. So in addition to exceedance to contamination that is above what was there before in its natural state and condition, there's also actual harm. And then there's also harm to the realty from the deed notifications, the uncertainty of risk. Your Honor, Gibbons Creek plant, I think, is a very good example in the state of Texas, where supposedly it's been reclaimed and cleaned up and no one will buy it. It's that fear, that reputational harm due to these constituents that, as we learn more and more about them, are more and more harmful. Your Honor, the Railroad Commission reclamation regulations do not require an ecological risk assessment to determine whether they have been met. In fact, San Miguel's mine reclamation expert had never heard of an ecological risk assessment in his 40 years of working in the field. The lease does not incorporate any language about probability or harm. It says restore to the original state and condition. And the areas outside the lease premises are not subject to any regulatory oversight at all, as San Miguel's expert Mark Hemingway confirmed. He also testified that he was able to delineate contamination by visual observation of dead vegetation co-located in a known area of wastewater release. And Dave Burris, the fuels manager and a Texas registered professional engineer and San Miguel's corporate representative, testified the same. Dr. Verslecki's opinion is that you cannot look at dead vegetation in the area of a known release and know with any certainty that that has caused the dead vegetation. And instead, you have to do this esoteric and irrelevant risk analysis. That's how far he takes his opinion. So it's not just that we can't look at areas beyond where there's dead vegetation. He's saying that if there's dead vegetation, that's not ecological risk. First of all, because no one's going to eat vegetation that's not there. So there's no actual wildlife receptor eating the plants. And in Texas, Mr. Schneider is incorrect. Vegetation is not evaluated for harm. It's only wildlife receptors under an ecological risk assessment. So if the grass is dead in Texas, it doesn't matter to the regulatory agency, because then it would never have a complete exposure to a wildlife receptor because they can't eat what's dead. So it just introduces this whole crazy, esoteric, irrelevant risk assessment discussion to a common law case. I mean, it would be a huge change in the law to read in this requirement of an ecological risk assessment in order to show trespass and negligent property damage harm in the state of Texas.
I'm not thinking about requiring one, but just whether it might have any relevance to the jury to show if a particular trespass was a problem. I mean, if somebody drops their glow-in-the-dark watch into a piece of machinery and it gets ground up, it could release tritium, which is radioactive. But I don't know what it follows that you can say, well, we've got radioactive contamination. We're entitled to vast sums of money because they trespass this radioactive contamination onto the property. I don't know if you would be able to just do that. Or you would
if you can't sell the property, then I think it would cause a loss. It would cause damages.
Yeah, but are we talking about nominal damages? I mean,
this property is worth quite a lot. It's not nominal damages, or it would have been had all of this not occurred.
Right, but you can go to a jeweler's in San Antonio and find, or anywhere else, it's a big city, and find dozens of watches with glow-in-the-dark dials. I mean, there's got to be some level, it seems to me. All right, I'm sorry, go ahead.
That's all, Your Honor.
Okay, all right.
Your Honor, if I may very quickly clarify the record on just a couple of points in response to your questions.
Go ahead.
I just wanted to quickly address your question about whether the peelers need to show if there's a problem with their land, and Ms. Weddle said they have. With respect to the soil disaggregation, that's the area that is to the northeast of the power plant that is currently being remediated under the Texas Risk Remediation Program. There is evidence in the record that shows that while the power plant likely contributed to some of that soil disaggregation, that there are other potential causes. That's something that Mr. Hemingway testified to, and I know you'll hear more about that when you hear more about Mr. Hemingway later. That is actually somewhere where ecological risk assessment could be a really helpful tool, because it's somewhere where we can look at what were the multiple potential causes of that soil disaggregation. Secondly, on the issue of groundwater damage, the groundwater that's alleged to be damaged here is a shallow unit that has very high levels of natural salinity. So it's not an aquifer that anyone was using anyway. And that is something that an ecological risk assessment would take into account. It would think about how the groundwater was before, what it looks like now, and whether it has changed the state of the environment, whether it would harm plants in a different way now than it would have before. And that's all, Your Honor. Thank you.
Chernetsky, how does the other next witness pronounce their name?
Charnetsky, that's correct, Your Honor.
All right, who's going to argue that?
Your Honor, Bob Schick on behalf of San Miguel and Steck, although Mr. Kirstein or Mr. Butler may weigh in.
That's correct, Your Honor. Steck would just need about 5 minutes at the end, I think, Your Honor.
Go ahead, sir.
Mark Guerrero for the peelers.
Thank you, Your Honor. San Miguel and Steck are moving the court to exclude the testimony of the peelers' accounting expert, Paul Charnetsky. Mr. Charnetsky's testimony is not relevant either to the peelers' breach of contract claims or to the remaining tort claims that survive this case. Just to refresh the court's memory, the breach of contract claims that are asserted by the peelers are that San Miguel failed to commence reclamation in a timely manner, complete that reclamation with diligence, save and replace topsoil removed, plant grasses selected by the peelers, and pay surface damages as required by the contract, the mineral lease. The peelers have not asserted a breach of contract for any accounting obligation. They didn't claim there was a breach of an accounting obligation, nor could they, because neither the mineral lease nor the buffer zone lease contain a single provision regarding accounting requirements for a rural electric cooperative. And I'm going to continually come back to a rural electric cooperative because that's what we're talking about here. But that is the basis of Mr. Charnetsky's opinion. The peelers claim that Charnetsky's opinions are relevant because the jury will determine if there has been a delay in reclamation and whether damages have resulted. And yet, based on his deposition testimony and his expert report, Judge, Charnetsky gives no opinion regarding the consequences of accounting failures at all. He doesn't say there was an accounting failure and therefore it led to damage. He doesn't say that at all. Instead, he actually asserted, and I quote, "I don't make any opinion that San Miguel will not be able to pay at some point in the future." And perhaps more importantly, he says that he has no opinion as to whether San Miguel failed to reclaim the peelers' property timely because of a lack of funding. So he is unable to establish a nexus between his specialty, accounting, and I'm going to get into the specialty later on, and any of the damages or causes of action asserted by the peelers. In fact, what Mr. Charnetsky did in his deposition testimony was completely undermine the claims that are being made by the peelers' lawyers that San Miguel failed to timely reclaim because of a lack of funding. But that's exactly what they told this court back in March when we had a hearing on our motion to strike the report of Charnetsky as not being relevant to any of the issues in the case, and it's contained in their briefing with respect to this motion. But Your Honor, even if Charnetsky were able to offer that opinion, connecting an accounting failure to some damage that's going to be claimed, it's not relevant here because the jury is going to be asked whether San Miguel breached the contract, the lease. I was glad to see Ms. Whittle reference the pattern jury charge because it's a very simple question with respect to breach of contract. The question will be, did San Miguel fail to comply with the lease? If so, what are the damages that flow from it? Jurors are never asked to determine why someone breached the lease. They're simply asked, did the defendant, did this party breach the lease? And you may have instructions under that question, Your Honor, that cite various provisions of the lease that the peelers claim have been breached so that the jury can go through those. But ultimately, the question is simply, did San Miguel breach the lease? Why has nothing to do with it. There's no pattern jury charge question about then find out why they breached the lease. What does that go to? It's not an ultimate issue of fact. Charnetsky's opinion does nothing to make the existence of breach of lease either more or less likely, which is the test for relevance. Similarly, his opinions are not relevant to the remaining tort claims. In the tort context, for example, the jury is going to be asked the question, did the negligence, if any, of those named below proximately cause the injury or harm in question? Charnetsky offers no opinion that accounting errors caused or contributed to cause contamination of the peeler property off the leased premises, which is the basis of those tort claims. And he makes no connection, zero, between alleged accounting errors and the claim that reclamation was somehow delayed. And here's what's most important, Judge, nor does any other expert. It's not as though the peelers are relying on some other expert to then be bootstrapped by Charnetsky. No peeler expert is able to make a connection between any alleged accounting error and a claim that reclamation was delayed. And I'll say again, there's been no assertion of a breach of accounting, nor has there been a claim of negligent accounting asserted in this case. With all due respect, Your Honor, it seems to me that it's time for us to take a look at how this case is actually going to get tried. And this academic exercise relating to accounting is just that. It's not helpful to the court. It's not going to be an issue the jury will be asked to determine. Instead, it is a side issue and a side show. Moreover, Your Honor, Mr. Charnetsky's opinions are unreliable. And here I don't know whether the court's had an opportunity to read either our motion or our reply, but I will refer you to our reply and the exhibits there attached. But Charnetsky,
reply.
I'm sorry?
I've read your motion and the peeler's response. I have not read the reply.
Okay, thank you, Judge. What Mr. Charnetsky says is that San Miguel failed to account for certain reclamation obligations. That's just simply not true. And this is where I rely on the exhibits that are attached both to our motion and the reply. San Miguel's audited financial statements are prepared by an independent licensed third-party accounting firm. And those statements are required on an annual basis to be submitted both to the Railroad Commission and to the Rural Utilities Service, the RUS. And there is no question but that reclamation and restoration costs are all included in those statements, as our exhibits demonstrate. Some of the reclamation, for example, Your Honor, is you'll see it described as mine closure costs. Well, when we're talking about mine closure, we're talking about the reclamation, the completion of restoring the property to as near its, and the wording of the lease, by the way, is as near to its original condition as is practicable. Charnetsky's opinion is furthermore unreliable insofar as he gives the opinion that San Miguel's rates are not competitive in the Texas electric market, and that San Miguel may one day face a decline in demand. Well, the problem with that opinion, of course, is that it's not a jury issue. What difference does it make whether there may be some challenge to selling electricity at certain rates? And it's speculative. Who knows what's going to happen? I didn't think I'd see natural gas prices above $1.80 over the last 2 years, and yet here we are, natural gas prices are at $3. It is not relevant to the breach of contract claim. It could be relevant, that is, what might happen in the market and what the demand might be for San Miguel's power if they had a cause of action for anticipatory repudiation or an anticipatory breach. If for some reason they said, well, San Miguel's breached because they're looking out to the future and they've got a problem, but that is not what they've asserted here. Moreover, it's unduly prejudicial. Furthermore, Your Honor, Mr. Charnetsky's opinions are not based on a reliable methodology. The peelers themselves admit that he failed to apply the Rural Utility Service accounting standards. Those are the very standards that cooperatives like San Miguel are required to use. Those standards comprise a subspecialty of accounting for which Mr. Charnetsky has zero in the way of qualifications. We cite the court to the Texas Supreme Court case of 96, Broaders versus Heiss, to suggest that a person with general expertise, like Charnetsky, who at one time was a CPA, may not be qualified to offer expert opinions in areas of that general discipline that are specialized. So he doesn't have that experience. He has no experience in accounting for rural electric cooperatives, and he made no attempt to apply them or even to review those standards in preparing his report and giving his deposition. Next, the peelers suggest that Mr. Charnetsky's opinions may be relevant to their claim for punitive damages. Well, punitive damages, as we all know, can't be recovered for a breach of contract claim. So let's talk about whether they might be recovered here as to the negligence or tort claims that remain. Remember, they are not claiming that there was any negligent accounting. That is nowhere. So their Ford analogy simply doesn't work because in the Ford case, the allegation, of course, was defective design. But here, the claim is negligence in mining and in reclamation. And no expert, including Charnetsky, on the peeler side of the equation suggests that any accounting errors led to negligent or delayed action to reclaim by San Miguel. Only the peelers' lawyers say that. Moreover, if we step back a moment, we know that to recover punitive damages, the peelers first must establish gross negligence. Of course, the way it gets submitted to a jury, as we all know, is the first question is, was San Miguel negligent? And I presume in this instance, with respect to its accounting principles and its accounting methodology. If the jury were to answer that yes, and of course that issue doesn't get submitted because it's not been pled, then presumably the next question would be, and was that negligence gross negligence? But they've got to prove a connection between the accounting practices and the deficiencies in reclamation and restoration. And they can't do that because they have no expert testimony, none of their experts. Moreover, San Miguel's accounting actions then must be found to establish gross negligence to have involved, and mind you, this is accounting practices, must be found to have involved an extreme risk considering the probability and magnitude of potential harm to others, of which it had actual subjective awareness of the risk involved, but nevertheless proceeded with conscious indifference to the right, safety, and welfare of others. By an accounting practice, there's no proof, there's no evidence, and there is no expert testimony that establishes those facts or the underpinning for a jury to be able to answer that question. And that question can't be submitted to the jury because the predicate question of was San Miguel negligent in its accounting practices hasn't been pled, and that won't be going to a jury. San Miguel provided audited statements. It submitted those to the Railroad Commission and to the RUS. The peelers have them. They're matters of public record with respect to the Railroad Commission. Moreover, as we've mentioned to the court before, San Miguel has obtained reclamation bonds on the basis of those statements, and those statements include those costs that are being amortized over time and the money accumulated for the purposes of reclamation, restoration, mine closure. Finally, Your Honor, I guess I can mention the fact that we can certainly ask the court to bifurcate this case, and making it completely and utterly irrelevant without any doubt about it for the case in chief. But that's something that we can do anytime before voir dire. There is one example I'd like to point out to the court where Charnetsky gets it absolutely wrong. He talks about, and you've heard the Peelers Council talk about the 2015 coal combustion residual rule of the EPA that came out during the Obama administration, which created an obligation to decommission ash ponds like the 2 or 3 ponds that are on the plant site. And that's the plant, of course, is owned by San Miguel. And then in August of that year, in August of 2015, the board of directors created a plant decommissioning asset retirement obligation called an ARO. And that was to be effective on January 1, 2016. By the end of 2017, San Miguel had accrued over $4 million as plant decommissioning liability. They have that money accounted for, and it's a matter of public record. It's in our exhibits. And yet it's entirely ignored by Charnetsky because his approach was to simply look at the state and the value of San Miguel as of December 31, 2015, period. Judge, we acknowledge that San Miguel would have to pay for restoration and remediation costs as required by the leases and the Railroad Commission permit if there has been a breach. The only question for a jury is going to be, did San Miguel breach by an unexcused delay? And if so, what damages were incurred by the Peelers by virtue of that delay? It's essentially the same question when it comes to the tort side of the case. Allowing Charnetsky to testify will confuse the jury. It will prejudice San Miguel and Steck. And I would point out, will take up at least 2 full days of this court and jury's time on something they're never going to be asked a question about. And it is on that basis that we ask the court to grant this motion. And I will add one other footnote for you to consider, Judge, and that is, if Charnetsky is not allowed to testify, if the court grants this motion, we will be pulling down our designation of our expert, Michael Barrett, who is qualified to talk about RUS standards and this kind of accounting for rural electric cooperatives. We will not offer him as a witness, period. Thank you, Your Honor.
Mr. Butler?
Judge, I'm going to handle the 5 minutes if that's okay.
Go ahead.
Thank you, Judge. Certainly, Judge Steck echoes the objections that Mr. Schick just discussed, and we have joined in on that motion. The reason for the extra 5 minutes, Your Honor, is just as Kiewit has needed at some of these hearings to separate itself from the other motions or the other arguments being made because it sits in different shoes. With regard to Mr. Charnetsky, Steck believes that there's one extra issue that we want to bring to the court's attention and kind of an extra objection, so to speak. As you've heard, this is clearly a San Miguel accounting issue that Mr. Charnetsky proposes to testify on. He's testifying regarding their accounting methods, their accounting tax returns, and how they have handled their assets and liabilities. It is in no way a Steck accounting issue. And so for that reason, in looking through Mr. Charnetsky's report, we wanted to make sure to see if he was going to give any opinions against Steck. And while it is difficult to determine if he is, there is one line from his initial report that I want to read to the court, which is kind of the basis for this objection. In his opinion number 2 of his report, and this is a quote from that, he says, San Miguel and Steck failed to appropriately account for the settlement and as a result, underreported San Miguel asset, retirement obligations and environmental liabilities, or overstated the value of San Miguel assets since at least December 31, 2015. So in that opinion summary, he does bunch together San Miguel and STEC, and he seems to indicate that STEC has failed in some accounting way in handling the San Miguel accounting, which I won't get into, well, I will in just a minute, but it doesn't make any sense because these are clearly, again, San Miguel returns and San Miguel accounting issues. When you look to the body of Mr. Charnetsky's report, he discusses the management services agreement briefly and doesn't seem to give any other conclusionary statements indicting STEC regarding San Miguel's accounting. But because that opinion is in his opinion summary, and to the extent that Mr. Charnetsky is going to go beyond San Miguel accounting issues, we need to raise that objection, because if Mr. Charnetsky tries to give opinions that under the management services agreement, and let me just back up, you may remember, Judge, from the argument a couple of weeks ago on the STEC motion for summary judgment on the tort claims, we argued a lot about that management services agreement that is between San Miguel and STEC, providing that Mr. Kezar would be the general manager of San Miguel under that agreement. To the extent Mr. Charnetsky gives opinions that STEC is liable for anything under that agreement, we would object, and we would argue that that goes well beyond his alleged expertise and really what the purpose of his hiring was. He testified in his deposition that his job was to determine if San Miguel's accounting was correct in 2015, not whether STEC complied in any way or didn't comply with the management services agreement. And so very quickly, Your Honor, to the extent that he is going to offer opinions that STEC is responsible for anything under that MSA, we would first object that it's irrelevant. The claims remaining against STEC are the tort claims that are the subject of that pending summary judgment motion for damages to property outside of the lease boundaries. As Mr. Schick said, the jury is going to get asked questions about trespass and negligence. They are not going to get asked questions whether STEC allegedly violated an MSA agreement with San Miguel. That's an issue between San Miguel and STEC. They're going to get asked questions whether we were negligent in relation to the Peeler property and whether we trespassed or caused trespass on the Peeler property. There is nothing that Mr. Charnetsky can say with regard to STEC that involves those issues, those tort issues in any way. Secondly, it's clearly not reliable, and to not be repetitive, but it doesn't help with any of the fact issues that a jury is going to be asked. And the reason he did no analysis, gives no basis or reasoning for this conclusionary line that STEC failed to account for the Brazos settlement. And the reason he didn't give any analysis is really the last two reasons for our objection, Your Honor. First of all, he's not competent and doesn't have the expertise to give the court or the jury any conclusions regarding STEC's liability under an MSA. He is an alleged accounting expert. He is giving accounting opinions regarding San Miguel's accounting. He is not an expert on interpreting or giving the court direction on a management service agreement between two electric co-ops. Secondly, Judge, it's a pure question of law, and that's why he didn't do any analysis as well. It's a total conclusionary statement to simply state in his report that STEC failed to do something for San Miguel that was San Miguel's alleged obligation is, again, a pure conclusion of law, not a mixture of fact and law. And to the extent that MSA is even relevant in the case at the time that it gets to the jury, and to the extent it is an unambiguous contract, Your Honor, that's going to be a question of law for the court. It's going to be for the court to tell us how that contract should be interpreted. It is not going to be for an alleged accounting expert to kind of throw in an opinion that STEC had certain obligations or didn't have certain obligations for San Miguel's accounting. And so, Judge, STEC would separately object, in addition to everything that Mr. Schick said. We would argue that this expert, to the extent he's allowed, if at all, should only be allowed against San Miguel. and should not be allowed to give opinions against STEC because the San Miguel accounting issues are the 100% total subject matter of what Mr. Charnetsky purports to give opinions on. And again, we don't think he should be allowed at all, but he certainly shouldn't be allowed to give opinions against STEC related to that management services agreement, Your Honor.
And how would you, and for all of these, I guess Mr. Schneider might need to address this too. If the testimony is only available against one party, how would you want to actually make that happen?
Well, so I'm not speaking for Cody on this one, but as to Mr. Charnetsky, I guess what I'm really asking for, Judge, is that he not be allowed to give opinions against STEC, that STEC is liable for something. That's not his role. That's not what he was hired to do, and he's not qualified to do it. So as to me, if you agree with my argument, it would simply be that Mr. Charnetsky would not be issuing opinions against STEC. And so I think that would take care of itself. Maybe there would be an instruction as well at the time certain experts are offered. But I think that would take care of it for STEC because he wouldn't be offering any opinion against STEC.
Okay, thank you.
In Your Honor, if you would like me to address that, I'd be happy to. And I think Mr. Guthrie might want to as well chime in from Kiewit Mining Group's perspective, but I think he might have been on mute a moment ago.
I was, and let me take over here, Cody. Thank you. Your Honor, I think in line with Mr. Kirstein's statement, the best way to handle the situation that you raised where testimony is admissible against one party and not admissible against another would be jury instructions, contemporaneously with the testimony. I don't know how else to do it. I can think about that, but that's my initial reaction.
Okay, all right, thank you.
Thank you.
Anything else from KMG on this issue, on this witness? Or did you didn't join in the motion, or did you?
No, Your Honor, we did not join in the motion. We
Okay.
certainly don't oppose the San Miguel motion. We just don't have anything to add to it, and we didn't join.
Ms. Whittle?
I'll be responding on behalf of the
Oh, I'm sorry, you did say that, Mr. Guerrero, you did.
No problem. May it please the court. The coal companies take issue with both the relevance of Mr. Charnetsky's opinions and the reliability of his opinion. But the relevance issue has already been decided by the court in March 2020 when we heard this at a hearing in March 2020. And as Ms. Whittle stated at the hearing, in March on this issue, she put it plainly, and what she said back then still applies now. She said, Mr. Charnetsky's report is relevant to the peeler's claims for breach of contract, negligence, exemplary damages, and a cleanup order. San Miguel and STEC are bound by the mineral lease contractual language to act without delay and in a manner which is feasible and reasonably practicable. San Miguel has known about the problems on the Peeler Range since as early as 2004, and their experts provided them with alternatives to repair and restore the range. They never set aside the money to do the work that their own experts told them would be required. And the responsive report that San Miguel's expert provided suggested that maybe by 2037, they will have accrued the necessary money to do the work. And we would argue that that's not timely. It doesn't meet the contract terms of undue delay and what is feasible and reasonably practicable. At some point, there is a point of no return, either economically or because it just can't be done scientifically. It is relevant that they did not set aside the money back when they knew they had these obligations. San Miguel and STEC's failure to follow accepted accounting principles and account for long-term obligations has caused and will continue to cause undue delay in initiation and fulfillment of their cleanup obligations because they don't have the money and they're not doing the work. That's what Ms. Whittle said back in March, and it applies equally here today. To put a finer point on it, Judge Wilson, I'll focus on one area of damage that Mr. Kirstein and Mr. Schick didn't talk about at all. The damage that occurred in the mine area, but due to the passage, actually, what I'll talk about is specifically the seeps that Mr. Kazar talked about during his deposition.
Go ahead.
Sure. I'm going to share my screen here. And Your Honor, these are the seeps that we're talking about. These are the seeps that we're talking about. These are seeps in the mine area. Some of these are aerial photographs. But these are the seeps that Mr. Kazar identified that San Miguel knew about as early as 2004. The peelers experts, both Gordon Johnson and Anthony Brown, in declarations that are already on file with the court, filed with the peelers' response to Steck's motion for summary judgment regarding tort claims, opined that a cause of these seeps was the accumulation of massive amounts of wastewater in pit 10 and the disposal of coal ash in an open pit over 50 feet above the ground for many acres. These seeps that Mr. Kazar identified in 2004 demonstrate that this wastewater has infiltrated the reclaimed spoil in Area A and have worsened over time, spreading to an area outside of the lease boundary. Mr. Kazar acknowledged that as of the date of his deposition, that he had not included, that San Miguel had not included the fix for the seeps in their long-term accounting. And this is Mr. Kazar's actual deposition testimony. Here, he states that he first identified the seeps in Area A of the mine in the 2003-2004 time period. Here at page 182 of his deposition, and these excerpts are attached to the plaintiff's response, he states that the seeps have expanded over time. He's asked, what would you say the seep problem has expanded over the years? And his response is, how the seeps have manifested themselves have expanded over the years, yes. So do you think that previously the spoil was infiltrated with water and it's just daylighting in more areas now? And his answer is, I think over time, the water in that pit has infiltrated the spoil. And yes, it's popping up in areas now, lower elevations. He also acknowledged that as of the date of his deposition, the fix for the seeps that had been identified in 2004 had not been included in the long-term accounting. He was asked, would these long-term liabilities include reclaiming the spoiled water infiltration and seeps in Area A of the mine on the Peeler Ranch? He responds, not to my knowledge. Why not? I don't think that these costs have been quantified. Mr. Kazar's deposition was taken in November 2019 as an aside. He was asked, why haven't they been quantified? He responds, we are working our way through the process now of determining what we'll do, what those impacts will be. How long have you been working your way through that process? Which process, he asked, of determining what you will do to address the end pit water, the seeps, and the soil infiltration in Area A of the Peeler Ranch? He responds, we've been working on that for a number of years. He's asked, would it be fair to say that you've been working on it since approximately 2004? And Mr. Kazar says, that's probably fair. So why is this important? Without this accounting for this particular problem, and there are other long-term obligations that are accounted for, and we're only focusing on this one for the purposes of today, the money to fix this problem will not be recovered in the rates, and therefore the problem will go unaddressed, which is exactly what has happened for years and years. At the most basic of levels, there's not a complicated analysis that is required here. It is common sense that one of the first steps in addressing a problem is not only to analyze the problem, but look at the resources that are available for you to fix the problem. For example, if there's a leak in my roof, part of the analysis is, can the roof I have be patched? How much of the roof needs to be repaired? Do I need a new roof? How far damaged is the sofa that got wet and the rug? An indispensable part of this process is to say, how much will this cost? Where do I get the money? How much will I have to save? Based on how much it costs, how quickly can I get it done to avoid further damage? This is where Mr. Charnetsky's opinion becomes relevant on many fronts. What I'll show to the court now is the mineral lease. And the language in the mineral lease is going to be important. The jury's going to be asked to determine if there's been a breach. And the language that's pertinent to Mr. Charnetsky's opinion is what's underlined in red. I'll start at the top. Lessees agree within 6 months after the abandonment of any excavated area located on the leased premises that it will commence operations to level and restore the surface thereof to the extent which is feasible and reasonably practicable, and will diligently prosecute such operations to completion without undue delay. There are issues in there that are relevant to Mr. Charnetsky's opinion, such as whether or not it was feasible. If they don't have the money, it's not going to be feasible. It's not going to be reasonably practicable. If they didn't save the money, was there undue delay introduced into the process? These are relevant to the issue of breach of contract. Under the negligence claim, did San Miguel act reasonably in not accounting for the seeps? Under our exemplary damages claim, whether or not Mr. Schick or Mr. Kirstein feel that we can prevail in our exemplary damages claim, that's not an issue that's before the court today, and it's irrelevant to the issue of whether Mr. Charnetsky's testimony is admissible. But under our exemplary damages claim, apart from San Miguel's duty to refrain from harming the peelers, San Miguel was under a separate accounting obligation to address long-term obligations, but they didn't. San Miguel and Stex disregarded their legal duty to the peelers in combination with a simultaneous and purposeful violation of accepted accounting practices is relevant to the jury's determination of exemplary damages. As explained by Ms. Whittle at the previous hearing on the failed motion to strike Mr. Charnetsky back in March, it's akin, Mr. Schick referenced this, it is akin to evidence regarding the money saved by Ford Motor Company in failing to use a 10-cent piece on a fuel tank that would have prevented the release of gas in a collision. Here, by failing to set appropriate rates that include sufficient reserves, San Miguel's customer, Steck, who was also its manager, paid less for its take of San Miguel's energy. That cost savings is relevant to the issue of whether exemplary damages are warranted in this case. Mr. Charnetsky's opinions are clearly relevant and should not be excluded on relevance grounds. I'll next turn to San Miguel and Steck's arguments that his opinions are unreliable. First of all,
let me ask just for a moment, what is the appropriate accounting standard to determine when a large entity who has a big physical footprint, does some industrial process, how it determines what its future environmental liabilities are for cleanup and shutdown?
Mr. Charnetsky, Judge, explains this in more detail in his report. But what he says is that organizations like San Miguel are under an obligation to account for a long-term environmental obligation, for example, when that becomes probable, when it becomes probable that they're going to have to fix an issue. And this is why we focus here on the issues that were identified in 2004. It is now 2020. Those seeps still exist. And so when Mr. Kazar identified that the seeps were a problem in 2004, those should have been accounted for in a timely manner thereafter, because under the lease, San Miguel is required to fix those seeps, but they didn't do that. And so what happened is the seeps grew and impacted an area not only within the mine area, but it's extended outside of the lease boundary. And so once the entity knows that such an obligation is probable, and again, that's explained more thoroughly in Mr. Charnetsky's report, which is attached to our response. So San Miguel and Steck also claim that Mr. Charnetsky's opinions are unreliable. Importantly, they don't challenge his qualifications, although both Mr. Kirstein and Mr. Schick seem to suggest that he is not qualified. Their motion to exclude him did not specifically challenge his qualifications. Mr. Charnetsky is a CPA not currently licensed, but he has a master's in industrial administration. He has 40 years of experience with a large part of his career assisting public utilities and telecom companies. He has experience as an auditor and has consulted on matters involving application of accounting principles and valuation, and has designed phase-in plans for public utilities and models to account for the effect of large additions to the rate base on utility finance. So he has experience in the industry. In explaining his methodology, Mr. Charnetsky cited his use of the Financial Accounting Standards Board, that's FOSB. They're generally accepted accounting standards, GAAP, which the court is familiar with. These standards are embodied in the Accounting Standards Codification, which are often referred to as the ASC. The ASC supports Mr. Charnetsky's method of using the Brazos settlement to determine San Miguel's value. What's important is the coal companies, they don't say that Mr. Charnetsky should not apply GAAP and the ASC. Essentially, what they're saying is they don't like the conclusion that Mr. Charnetsky reaches regarding San Miguel's fair value. That's important because they're not saying that applying GAAP or applying the ASC is the wrong way to approach this. They're saying that they don't like the conclusion. But the GAAP analysis is straightforward. Mr. Charnetsky explained that under ASC 820, an actual transaction between market participants provides the best measure of the fair value of an entity. Here, the transaction was the litigation settlement between San Miguel and Brazos. Under ASC 820, and this is the language that he applied, the price paid in a given transaction can provide the basis for a fair value determination, provided that the relevant assets and liabilities are transferred, one, in an orderly transaction, and two, that is between market participants. I'll start with the second element first, that is between market participants. Brazos and Steck were each clearly market participants. Both were purchasers of energy from ERCOT for the purpose of deploying such energy to consumers. As to the first element, ASC 820 distinguishes an orderly transaction from one that is forced, explaining a transaction is forced if it occurs under duress or the seller otherwise is forced to accept a price that a willing market participant would not. Importantly, nowhere in San Miguel and Steck's briefing do they cite any ASC provision that states that using a litigation settlement to arrive at San Miguel's fair value is not permissible. And they don't cite it because the ASC doesn't include any such language. Understanding that no such prohibition exists, they next attempt to paint the Brazos settlement as a forced transaction, asserting that it therefore does not provide a permissible basis for a determination of fair value. But as Mr. Charnetsky explained in his report, the Brazos settlement was in no way a forced transaction. The transaction negotiated between Steck and Brazos meets the accounting standards of fair value. This is the cite from Mr. Charnetsky's report, which is attached as Exhibit B to our response. Both parties were knowledgeable about San Miguel. Both parties had alternatives to making an agreement. For example, Brazos and Steck could have continued their litigation, but they chose not to. Brazos could have accepted Steck's dispatch of San Miguel, but it chose not to. Or Steck could have accepted Brazos's plan. Instead, Brazos accepted surrendering its half of San Miguel and paying an additional $127.5 million, and Steck accepted the money and provided indemnity. Tellingly, if you look at the Samaki and at San Miguel and Steck's own description of the circumstances of Brazos's exit, it clearly establishes that it was not forced. This is their motion at page 3 and page 4. And here's how they describe the transaction. At the end of 2015, Brazos and its members decided to leave San Miguel. They decided to leave San Miguel. That is precisely what they did. This was not a forced transaction. Again, to distract from this straightforward analysis, San Miguel and Steck contend that using a litigation settlement to arrive at San Miguel's fair value is not permissible under the relevant accounting standards. Again, it's not supported by the accounting literature, their position. Such a rule simply does not exist. If such a rule existed, it would lead to an absurd result. In any settlement negotiation where a market valuation has been performed by one or more of the litigating parties, which is a common practice, the value of the relevant settlement would somehow be excluded as a basis for fair value, simply because it was calculated in connection with litigation. No such rule exists, and San Miguel cannot point to any, and they don't. Mr. Charnetsky underlined the reasonableness of his determination of San Miguel's fair value in his deposition, observing that with an economically viable entity, one would not pay $127.5 million to no longer be part of that entity as Brazos did. He also further underlined that as part of the settlement, Brazos required an indemnity from STEC, indicating that the parties viewed San Miguel as a net liability. He also observed that Brazos had a chance to receive San Miguel's future cash flows and instead paid $127.5 million for the opportunity not to receive that value. All of these factors together support Mr. Charnetsky's reliance on the Brazos settlement, consistent with ASC 820's guidance on fair value. Brazos, a market participant with ample alternatives to settling the litigation, decided it was worthwhile to pay $127.5 million to exit San Miguel. I'm going to address a couple more points that are raised in the San Miguel and STEC's motion, but I wanted to point out here that, again, focusing on the fact that this is a motion to exclude Mr. Charnetsky's opinion, that it's not the role of the trial court to determine whether an expert's conclusions are correct, but only whether the analysis used to reach those conclusions is reliable. Here, Mr. Charnetsky applied the relevant ASC provisions and the relevant gap analysis. If San Miguel and STEC don't like the conclusion, that's something that they can vigorously question Mr. Charnetsky about, but it doesn't mean that his methodology in coming to his conclusions was unreliable. The San Miguel and STEC also spend a lot of time talking about specific cases, and I want to address that, but there are a couple of other arguments that they raise that I would consider red herrings, and I want to address them here. Mr. Charnetsky, as I said before, applied the gap standards. These are the ASC provisions that we discussed above. The coal companies seem to make an argument that he's not familiar with and didn't apply the Rural Accounting Services accounting standards. These are what Mr. Schick referred to. It's called the Uniform of System Accounts, which also apply to San Miguel at the same time as the gap standards. Importantly, if you look at the motion, at STEC and San Miguel's motions, they don't identify any specific standards relevant to evaluating the transaction between San Miguel, STEC, and Brazos, any relevant uniform system of account provisions. Moreover, in San Miguel and STEC's response to the Peeler's motion to exclude Mr. Barrett, which is going to be heard after this, they acknowledge that a more general practice accountant may also be qualified to opine on the issues in the case. And so I'm not saying that Mr. Charnetsky is a general practice accountant, but they have conceded that you don't have to have specific expertise in the uniform system of accounts. A more general practice accountant may also be qualified to opine on the issues. And again, they did not challenge his qualifications directly. To the extent they want to question Mr. Charnetsky's knowledge of the RUS standards, they can do so, and the jury can consider it as to the weight of the evidence. But here today, we're talking about the admissibility of his opinion, and this is not a basis on which to exclude Mr. Charnetsky's testimony. I'd also very quickly like to point to Mr. Barrett, and again, Mr. Barrett is the expert that was designated specifically to rebut Mr. Charnetsky. If you look at Mr. Barrett's report, under the provision at page 7, he talks about relevant accounting standards. And when he talks about relevant accounting standards, this begins on page 7 and goes over onto page 8. And this is also attached as Exhibit G to our response. He states the standards that are relevant to evaluating the transaction between San Miguel, STEC, and Brazos and the San Miguel accounting subsequent to the transaction. And he names ASC topics, topic 360, topic 410, topic 805, topic 820, topic 980, all ASC provisions. And so this argument that the RUS uniform system of account provisions are applicable are clear. They're clearly not as set forth by Mr. Barrett's report. I'm going to talk briefly, Your Honor, about the case law that the coal companies cite. Actually, before I do that, there's one other issue that I wanted to hit on. Mr. Schick referenced this during his argument. They make the argument in their motion that Mr. Charnetsky was confused as to the location of certain seeps. And what I'd like to say is that Mr. Charnetsky, they seem to suggest that Mr. Charnetsky needs to know, for example, the location of the boiler at the plant site. But he doesn't. San Miguel and Steck are responsible for the damage they cause to the peeler. And that is true whether that damage starts at the plant site, in the mine area, or outside the mine area. We've spent significant time talking about these boundaries in this case, but it's important to remember that plumes of contamination do not respect lease boundaries or plant boundaries. The peeler's experts, specifically Mr. Johnson and Mr. Brown, and their declarations are on file with the court, have opined that the seeps in area of the A of the mine have caused damage outside of the lease boundary. Mr. Charnetsky is not designated as an expert on the cause of the contamination, but solely for the proposition that San Miguel and Steck should timely account for known environmental obligations, whether those obligations are in the leased areas, on the power plant site, or outside the lease areas. Here again, the coal companies can question Mr. Charnetsky about his knowledge of the layout of the ranch, and the jury may consider that if it impacts their opinion, but it is an issue of weight, not an issue of admissibility. Now to the case law cited by the coal companies. The coal companies claim that Mr. Charnetsky's testimony is contrary to Texas law, specifically in two ways. First, they claim that Mr. Charnetsky's method of determining San Miguel's fair value, which we talked about before, incorrectly treats a litigation settlement as an arm's length transaction and is, quote, disfavored by Texas courts. It's a quote from their motion. However, the case law they cite doesn't disapprove of Mr. Charnetsky's method, but instead, to the contrary, makes clear that market value can be established by a wide variety of methods. For example, they cite the Mel Akers case, which is a Texas Supreme Court decision from 2014. This case only includes a passing reference to sales comparisons as an accepted and even favored means for determining the market value of land. It's silent as to regarding the valuation of a business such as San Miguel, and it doesn't mention the possibility that a valuation method might be disfavored. In fact, the court specifically refused to conclude that a particular method of valuation could never be used to reach a reliable opinion, even if the method had never been before approved by a legal authority. So it doesn't stand for this proposition that, as they claim, that there are favored and specifically disfavored methods. They also cite the Pike case, which is a recent case. It's a Texas Supreme Court case from 2020. The opinion is not yet finalized, and there's a Westlaw site. But the court said nothing whatsoever, again, about favored and disfavored techniques for determining market value. But instead, they clarified the distinction between book and market value. That's not a distinction that's at issue in this case. And the case has nothing at all to say about whether a litigation settlement might probably be used to establish the value of an entity. Furthermore, they cite a quote from Pike that market value could be established through evidence of price paid, nearby sales, tax valuations, appraisals, online resources, and any other relevant factors. This quote doesn't even support their point. The court is clear that any other relevant factors might be used to establish value. And the Pike opinion contains nothing excluding or even disfavoring the value of a litigation settlement as a proper relevant factor to consider. In fact, contrary to San Miguel and Steck's assertions, Texas courts have unambiguously recognized that settlements may be recognized settlements as admissible evidence of the value of an asset. And they did this in Adams versus State Farm Mutual Auto Insurance. That site is 264 Southwest 3rd, 424. The second area where they claim that Mr. Charnetsky's opinions are at odds with state law is they're saying that Texas case law has defined an arm's length transaction as one between unrelated parties only, and that here San Miguel and Brazos were not unrelated. But here again, they miscite multiple cases. Once again, they discussed the Mel Akers case, which we talked about earlier. They cite it for the proposition that an arm's length transaction is a voluntary transaction between two unrelated parties with generally equal bargaining power, each acting in its own interest and not involving a confidential relationship. The problem, though, is Mel Akers does not limit the analysis to whether the parties are related. Instead, in that case, the Texas Supreme Court plainly established that even an employer and an employee can engage in arm's length transactions, which squarely negates San Miguel and Steck's claim that transactions between entities with longstanding business relationships cannot be arm's length transactions. In the Schlumberger case, which again, this is a Texas Supreme Court decision, they held that two parties who both held interest in an ongoing deep sea diamond venture nevertheless dealt with each other in an arm's length transaction. Likewise, in Forest Oil, another Texas Supreme Court decision, just like in Schlumberger, the Texas Supreme Court found an oil and gas lessee and the owners of the burden leasehold dealt with each other in an arm's length transaction. They finally, in their reply, which I understand the court hasn't read, they mentioned this in their motion. They cite the Peckham case. But here again, in the Peckham case, that case involved a situation where there was a fiduciary duty between two partners. All of the cases cited by San Miguel and Steck have to do with a fiduciary relationship. Those cases are not applicable here because there's no suggestion of any fiduciary relationship between San Miguel and Brazos. So not only do San Miguel and Steck grossly misconstrue their purported legal authorities and fail to identify any legal authority precluding the use of the Brazos settlement to establish the value of San Miguel at the time, San Miguel and Steck can't even articulate a coherent theory of why Mr. Charnetsky's use of the settlement value is inappropriate. They haven't cited any ASC provisions. They haven't cited any case law, which is contrary to the arguments they make. And so what I would end with is Mr. Charnetsky's opinions are reliable and they will aid the jury and should not be excluded.
If I may, Your Honor, respond to something. Mr. Guerrero said that relevance was decided by this court in March, and while I acknowledge the court issued a ruling at that time, what's changed is that we took the deposition of Mr. Charnetsky. And as I pointed out in my opening presentation, we found out in his deposition that he is unable to make any connection at all, between what he claims are some accounting deficiencies or a negative value because of the settlement with Brazos and any of the damages or harm that the peelers are claiming. And so it's on the basis of that we are re-urging our motion with respect to relevance. And that is different from the many of the other motions that we've filed and that we're burdening the court with hearing with respect to Robinson-Daubert style challenges. Mr. Guerrero then said, well, the problem here is that with the accounting methodology, San Miguel may not have the money to do this work until 2037. Well, there are a couple problems with that. First of all, he ignores, and you've heard this before, the fact that over 3,000 acres of mined property have already been returned to the peelers. It's not like the entire leased area is still upset and yet to be returned to the peelers. They've had that returned to them. But to the extent that any of that acreage is not returned to them today, tomorrow, the time of trial, they have their cause of action for whatever harm they're able to demonstrate to the jury they've sustained as a consequence of that delay. No question about it. Mr. Guerrero spent some time quoting from Mr. Kezar's deposition about the fact that he knew of, or the company knew of, seeps in Area A as early as 2004. Well, there's no doubt about that. We've had all kinds of testimony about the things that San Miguel has attempted to fix those seeps, including a Class 5 injection well, getting a permit for it, using enhanced evaporation methods, a Class 1 injection well. There have been many methods tried, and it's still going on. And those costs of those attempts were handled out of the operating budget of San Miguel. No need to do long-term accounting. But then Your Honor asked a good question. Well, how do you account for these sort of long-term environmental liabilities? Mr. Guerrero answered, you've got to account for it when it becomes probable. That's not what the standard says. It's probable and estimable. So you not only have to have the probability of liability, you have to be able to estimate the cost. And San Miguel has been working with the Railroad Commission to deal with the various methodologies by which they can fix those seeps in Area A.
So if you just never arrive at a method for remediating the damage, then you never have to account for it because, well, we don't know what we're going to do, so we don't know how much it'll cost.
Well, Your Honor, there comes a point, certainly, at which it's going to become both probable and estimable. And based on what I understand, is very close as to that. But here's another problem, though. Mr. Guerrero pulls out from the entire remediation, restoration, and reclamation efforts what I said is accounted for as mine closure costs. He takes out one element of it. We have the entirety covered. The accounting does not take out each individual acre and say, what's it going to cost to repair this acre or these 50 acres? It is a larger process. He also says, well, we're not going to be, that San Miguel won't be able to recover these costs in their rates. Well, that's not what Mr. Charnetsky testified to. He's not able to testify to it. And simply the ipsy-dixit of the Peelers Council saying that that's the case doesn't make it so. And indeed, it is not so. Then he was explaining his analogy of the roof. And one of the things you have to know is how much is it going to cost to fix? Well, that's certainly not anything Mr. Charnetsky is able to address. It's Mr. Killian who's their expert on costs. Charnetsky has zero opinion with respect to costs and said he can't connect up any accounting deficiency with ability to recover. And then Mr. Guerrero showed you the language that I tried to quote about restore to as near as feasible as possible. And he said, well, it's the jury gets to determine whether it was feasible. No, they don't. The jury's going to be asked, did they comply with the lease provision or not? Period. Not, did they do it because it wasn't feasible? That's not a question to the jury. It's, did San Miguel breach the following lease provisions? And you may list them, either by question, which I don't think is the appropriate submission, or via instruction. Finally, Mr. Guerrero spent a lot of time talking about the Brazos settlement. And again, I'll say that's not relevant to anything. They're not a party to the lawsuit. It occurred at the end of 2015, and it has no bearing whatsoever on the causes of action that the Peelers are bringing here. Then finally, Mr. Guerrero suggested that we don't challenge the qualifications of Mr. Charnetsky. Not so. We do in our motion. I did in my presentation earlier. He has never worked for an electric cooperative. He is not familiar with the rural utility services accounting methodologies and did not look at their standards. That said, I ask the court to grant our motion to disqualify Mr. Charnetsky primarily on the basis of relevance, but also on the basis of his lack of qualifications, expertise, and inability to assist the jury.
Your Honor, can I just make 3 quick statements as to Steck?
Yes, sir.
Thank you, Judge. First thing I want to point out, Judge, is counsel was discussing in one of his reasons why Mr. Charnetsky's testimony is relevant. He talked about reclamation and restoration obligations under the mineral lease. I want to remind the court that the court has granted STEC's motion for summary judgment as to the mineral lease. And so those obligations that counsel was talking about do not apply to STEC, which is another reason that Mr. Charnetsky's opinions really do not apply to STEC and should not be allowed as to STEC. Secondly, I just want to point out, kind of as we argued in the tort motion for summary judgment, the fact that counsel continues to always bunch STEC and San Miguel together in everything they talk about, again, does not mean we are the same. These are not these are not STEC accounting issues. These are not STEC tax returns. These are not STEC accounting obligations regarding the Brazos settlement. All of that is unquestionably San Miguel obligations to handle in whatever way is determined to be correct. But I just want to point out again, that is what Mr. Charnetsky is testifying to, is San Miguel alleged accounting obligations, nothing as to STEC. And then as for qualifications, again, I adopt what Mr. Schick has argued, but I want to just reiterate that to the extent that Mr. Charnetsky is going to give an opinion, and maybe he won't, but to the extent he is, that STEC is responsible for something due to language in the MSA agreement, he is not qualified to do that. There's no reason he should be telling the court what an alleged unambiguous contract means or says. And so that is different than the other general accounting qualification arguments that are being made between counsel. There's been no argument, I don't think, by opposing counsel that Mr. Charnetsky is somehow qualified to tell the court what a management services agreement means or doesn't mean. So again, for those reasons, we would add on to what Mr. Schick argued, that he should not be allowed to give opinions as to STEC.
Ms. Guerrero, as to Mr. Schick's point about even if Mr. Verslaka's testimony might be, pardon me, Chernisky might be interesting, how is it relevant to the questions the jury is going to ask? If he doesn't say that they waited too long, now they can't raise enough money to repair these documents or repair the land?
Where they're relevant, Your Honor, and again, discussing the specific example that we've talked about and that the court was questioning Mr. Schick about, is when you look, for example, when you look at an environmental problem that's been known to San Miguel since 2004, like the seeps in Area A of the mine. When you look at that, what Mr. Charnetsky is going to say is that at the point at which the costs associated with those seeps, at the point at which they are probable, and as Mr. Schick says, estimable, San Miguel needs to account for them. They need to be included in the accounting. And in order for San Miguel to, what we have is a situation, Your Honor, where it is now 2020 and those seeps still exist. Those seeps still exist. They have not been addressed. And so one of the elements of that the jury has to look at is whether or not the delay that's been associated with not addressing those, they can look at it from different perspectives. One perspective they can look at it from is, is it technically possible for those to be fixed? Another element, like I said, when I said the roof example, did San Miguel take the steps necessary to quantify and estimate the cost to fix these seeps, to address these seeps? It's been 15 years since they were aware of them. And so part of our argument is that there is this independent duty that has to do with whether or not San Miguel is properly accounting for these costs. They have a duty to account for them under the accounting principles, under GAAP, but also the other side of the coin is, were they appropriately looking at how to address these issues? And we think that the jury gets to hear that testimony, particularly when it goes to the issue of whether or not San Miguel's conduct was reasonable, whether or not they injected undue delay and therefore breached the contract. And on the exemplary damages issue, whether or not their breach of this other of GAP just shows a course of conduct that was unreasonable that would support exemplary damages. So there's many different aspects in which this would be helpful to the jury in analyzing, what San Miguel's conduct was.
Your Honor, I'll just say this. The San Miguel has no duty to account to the peelers. The duty that Mr. Guerrero just mentioned has nothing to do with the lease. And there's nothing in the lease, nor is there anything in the common law that suggests that San Miguel has a
I'm sorry,
duty.
hold on.
Yeah, sure.
All right, I'm sorry. We've got a issue with somebody needs an emergency election order. All right.
Judge, that's all I had to say. There's no duty that San Miguel owes to the peelers on this issue whatsoever.
All right. Lachey, do you need a break before we start the next one? Okay. All right. It's 2:46. Let's come back at 3 o'clock, and let me also ask you to look at the the Word document from Ms. Whittle on revised scheduling date. Make sure everybody's happy with it, and I'll sign that. See y'all at 3. All right, and Mr. Guerrero, are you going to argue the Barrett motion?
Yes, Your Honor.
Okay, is everyone ready for that?
Yes, Your Honor.
Yes, Judge.
All right. Go ahead, sir.
Thank you, May it please the court. Your Honor, Mr. Barrett was designated by the coal companies as a rebuttal expert to rebut the opinions of Mr. Czarnecki. Each of Mr. Barrett's opinions are founded on his conclusion that San Miguel has at all times appropriately considered and accounted for all long-term obligations known to it. All of his opinions are an outgrowth of that one central opinion, and because of that, I'd like to focus my argument on this particular argument for his exclusion, although we've raised additional arguments in our motion. Specifically, the basis for exclusion is the analytical gap between Mr. Barrett's work and his ultimate conclusions. As we discussed earlier, the Peeler's expert, Mr. Czarnecki, is of the opinion that San Miguel has not appropriately accounted for known long-term obligations. And we discussed it with the example of the 2004 SEEPs. Mr. Czarnecki based his opinion on the deposition testimony of Mr. Kazar, which we went through earlier. And I'm not going to go through all of that deposition testimony. I'm going to go ahead and share my screen here. But it's the deposition testimony that we discussed earlier, whereby Mr. Kazar says that he's been aware of the SEEPs since 2004, and that the SEEPs have the manner in which the SEEPs have manifested themselves have expanded over the years. Again, this is what we looked at earlier. He also testifies that as the date of his deposition in November 2019, the cost to restore the land impacted by the SEEPs has yet to be included in San Miguel's accounting. We looked at that specific excerpt earlier. As the court is aware, Mr. Kazar is presently the general manager of both San Miguel and STEC, and he's had that position since 2016. In fact, Mr. Kazar actually started at San Miguel in 1980. He talked about that during his deposition. He's worked there continuously through 2014. During this time, when he worked solely for San Miguel, he was the general manager between 2008 and 2014. So his experience at San Miguel is both deep and long. Even after Mr. Kazar went to STEC in 2014, before the management agreement was signed between STEC and San Miguel, he testified he still had a role in the operation of San Miguel between 2014 and 2016. In sum, he has over 40 years of experience with San Miguel and its operations. As the court's also aware, Mr. Kirstein talked about this earlier, there's a management agreement between San Miguel and STEC. And one of Mr. Kazar's responsibilities under this management agreement is to maintain an overall day-to-day economic and technical profile of the operations of the co-op. Such economic and technical profile shall include, but not be limited to, performance of plant fuel, reliability, efficiency, RUS indenture, and other debt requirements and financial integrity. Also in the management agreement, his responsibilities include overseeing and direct preparation and implementation of the annual operating and capital budgets, and developing forms and reports which will provide the general manager with measures of economic and financial integrity. However, despite Mr. Kazar's clear testimony, despite his explicit responsibilities related to essentially all aspects of San Miguel's financial operations, and despite his over 40 years of experience at San Miguel, in response to the Peeler's argument that Mr. Barrett had failed to consider Mr. Kazar's testimony, STEC and San Miguel argue that Mr. Barrett is entitled, this is from their motion at page 11, I'm sorry, their response at page 11. They argue that Mr. Barrett is entitled to put more weight on San Miguel's audited financial statements than on misleading snippets of deposition testimony elicited from Mr. Kazar. Again, that's a quote from their response at page 11. What I want to do first is discuss the allegedly misleading snippets of deposition testimony of Mr. Kazar. Again, I don't want to review everything that we've already looked at, but I do want to look at this specific example. And it's what we talked about earlier. It's where he's talking about not having accounted for the seeps in the 2004 that he identified in 2004, not having accounted for those. We read this specific testimony earlier. Mr. Kizar acknowledges that they've been working on trying to quantify this since 2004, and he's saying that in 2019, so it's been 15 years. We would argue that the questions to Mr. Kizar that he was asked are not misleading, and we believe that Mr. Kizar's answers speak for themselves. In an effort to address Mr. Barrett's failure to consider this clear testimony from Mr. Kizar, San Miguel and Steck in their response essentially argue that Mr. Kizar doesn't know what he's talking about. If you look at page 12 of their motion, they say he's not an accountant. He doesn't have oversight of San Miguel's accounting department. He shouldn't be expected to know minutia of San Miguel's accounting without study. All of this ignoring his clear responsibilities under the management agreement and also his long tenure at San Miguel. So again, we don't believe that the snippets that we've cited are misleading of Mr. Kizar's deposition testimony. The second part of their argument is that Mr. Barrett can put more weight on the audited financial statement in coming to his opinion that San Miguel has at all times appropriately considered and accounted for all long-term obligations known to it. But here's the problem. The problem is that he's not putting more weight on the audit. He's accepting the audit as whole cloth, as his own opinion, in whole cloth as his own opinion. Mr. Barrett did nothing to confirm the accuracy or completeness of the outside work upon which he relied entirely upon when forming his opinions. The audit that he references is based on San Miguel's own prepared financial statements. During his deposition testimony, when asked, Mr. Barrett couldn't name the person at San Miguel who prepared the statements. The independent auditors then review these financial statements, but Mr. Barrett importantly took no steps himself to seek out or actually review those auditors' work papers. This is not an independent conclusion based on an actual review, but it's simply Mr. Barrett saying, the auditors said this was okay, so I said that this was okay, that they have accounted for all long-term obligations. An example of why this complete lack of foundation for his opinion is problematic is Mr. Barrett's testimony regarding the propriety of San Miguel's failure to quantify obligations associated with the seeps in Area A that were identified in 2004 per Mr. Kizar. When asked if it was appropriate for San Miguel to not have quantified and not have accounted for these seeps in the past 15 years, this is what he said. I asked him, do you think it's reasonable for San Miguel to have identified an obligation as far back as 2004, but to not quantify it and include it in their financials? This is at page 109 of his deposition, and it is included in our motion. He responds, yeah, I mean, if I was the auditor, I'd step back and say, what's taking so long? And try to understand the facts of what's going on. I also asked him, did you take any steps to determine? You said that if you were the auditor, you would ask some questions as to why it was taking so long. Did you do that? Did you ask San Miguel to provide any backup documents that discussed why it has taken since 2004 to quantify this expense? No, I did not, was his response. And this is the analytical gap. He talks about what he would have expected the auditors to do. Here, ask questions about why a particular long-term obligation had not been accounted for, yet he took no steps to determine whether or not the auditors actually asked those questions, and he himself did not ask those questions before coming to the conclusion that all long-term obligations were appropriately accounted for in reliance on the audit. Most tellingly, even though Mr. Barrett relies on the auditor's report in coming to the opinion that San Miguel has at all times appropriately considered and accounted for all long-term obligations known to it, when I asked him if he would endorse the auditor's conclusion that the financial statements present fairly in all material respects the position of San Miguel, here's how Mr. Barrett replied. He said, I mean, that's the standard opinion. This is at page 124 of his deposition. But you're asking me to agree with the opinion when I didn't do any of the work. So it's difficult to do. And that's precisely our point here today. Mr. Barrett didn't do any of the work. Mr. Barrett is San Miguel and Steck's expert. He could have asked to see the audit work papers, but he did not. And neither San Miguel or Steck provided these documents to him. So instead of doing a thorough review of the documentation, Mr. Barrett instead chose to come to a definitive conclusion based on incomplete facts. This is not reliable testimony and should be excluded. In their motion, San Miguel and Steck list other documents reviewed by Mr. Barrett, such as the earnings reports, annual reports, bylaws, the wholesale power contract, memoranda regarding capital investments and deferred revenue plans, but none of the documents listed involved obligations that were identified but excluded from San Miguel's accounting. What is notably missing from the list of documents reviewed by Mr. Barrett are not only the audit work papers, but also important studies that we've discussed before the court. For example, the Burns and McDonnell study is a study that was prepared in 2013, and the determination of whether that study will be produced by San Miguel is still before the court. But the purpose of that study, of the 2013 Burns and McDonnell study, was specifically to identify long-term environmental obligations associated with the San Miguel power plant. This study would likely clearly set forth long-term environmental obligations identified as early as 2013. This isn't one of the documents that was provided to Mr. Barrett. It's not on his list. In an effort to justify their failure to provide Mr. Barrett with the audit work papers, San Miguel and Steck take the position that the court's July 2019 order, which limited the discovery of certain financial information from San Miguel, is the reason that they were in essence prohibited from providing audit work papers to Mr. Barrett. We would argue that the court's July 2019 determination as to the discoverability of certain financial documents was limited in scope, and it was not intended to prevent San Miguel from providing necessary documents to their experts for a thorough, reliable review in coming to their conclusions. And we would ask the court to reject this argument. San Miguel cannot have it both ways, where it has an expert rely exclusively on an audit to support his conclusions, yet fail to provide Mr. Barrett or the peelers the supporting background regarding that audit. Mr. Barrett did nothing to independently investigate or identify San Miguel's actual long-term obligations before concluding that all had been appropriately accounted for. This opinion underlies each of his opinions that he's offering in this case, and because of the analytical gap that exists between the work he performed and his conclusion, his testimony should be excluded.
Mr. Chick?
Thank you, Your Honor. I'll respond to some of the specific items identified by Mr. Guerrero at the end of a relatively brief response. As I mentioned earlier, we designated Mr. Barrett solely out of an abundance of caution. We do not intend and will not call him as a witness if Mr. Charnetsky's testimony is excluded. The arguments that were just made, and I think this is true of the entire motion, clearly go to the weight and not the admissibility of Mr. Barrett's opinions to the extent that they're necessary at all. All the things that Mr. Guerrero just articulated are things that are easily handled on cross-examination, although I continue to suggest to the court that this really is taking the jury down a rabbit trail. But at this stage, what the court need consider, and what it only needs to consider, is whether Mr. Barrett is qualified and whether his opinions are reliable. And just to give you a sense, Judge, Mr. Barrett's exceptionally qualified to address accounting for a rural electric cooperative, something that Mr. Charnetsky is not. Mr. Barrett has a bachelor's in accounting and over 30 years of professional experience as an accountant specializing in electric utility industry accounting issues. He worked as an auditor for the Federal Power Commission, now known as FERC, or the Federal Energy Regulatory Commission. And in that role for the Power Commission, he was responsible for assuring that electric and gas utilities were in compliance with the Uniform System of Accounts, same system we talked about earlier, which is a special accounting standard that rural electric utility service borrowers like San Miguel must follow. He also worked as a utilities accountant at, and then became an audit partner at Ernst & Young. In fact, by the end of his career, he was the national director of Ernst & Young's utilities group. He oversaw the audits of many clients in this particular industry. And moreover, he acted as an advisor to other senior audit partners. These are people who've been doing this for a long time, and he was the go-to guru to answer their questions about industry-specific accounting standard problems. His private practice experience includes scores of audits of electric and gas utilities, including rural electric cooperatives and coal-fired power plants. Again, something that Mr. Charnetsky does not have. He also continually, to this day, provides training courses for the Corporate Accounting Committee of the Edison Electric Institute and the American Gas Association. Are his opinions reliable? Yes. He did much more than what Mr. Guerrero suggested. He reviewed San Miguel's financial statements, the earnings reports, the annual reports, the bylaws, the wholesale power contract, the management services agreement, their capital investments, their rate calculations, as well as documents related to the Brazos Electric settlement and deposition testimony, which we continue to suggest has no relevance to this lawsuit. He also reviewed email exchanges between the RUS and San Miguel relating to San Miguel's accounting of the Brazos settlement, which the RUS explicitly approved. That the peelers disagree with the conclusions that he reaches is no basis to exclude his testimony. Any disagreement between the experts is for the jury to sort through. San Miguel's audited financial statements were prepared by an independent licensed third-party accounting firm, not by San Miguel, as Mr. Guerrero seemed to imply. So let me respond to some of the specific items he pointed out. He began by talking about Mr. Kezar, and it is pronounced Kezar, and suggested that Mr. Barrett ignored some of the things that Kezar said, like we hadn't accounted for, because not estimable, seats that we knew existed in 2004. And in answer, and you raised this question with respect to Charnetsky, Your Honor, but money is being accumulated. Money has been accumulated, is accumulated from day one. When San Miguel began mining the Peeler property, it began accumulating funds that would take care of paying for all closure costs, including remediation and all restoration. So the money is there. They complained toward the tail end of his argument. He said, well, why didn't you give Mr. Barrett the Burns and McDonnell report done in 2013 in aid of the litigation settlement among Brazos, Steck, and San Miguel? Well, first, we say it's not relevant. Second, we say it's privileged. And you know, I certainly know, that had we turned that over to Mr. Barrett, then the plaintiffs, the Peelers counsel in this case, would have said, we're entitled to see it now. And we don't believe they are. Was it necessary for Mr. Barrett to see it? No, of course not. In fact, one of the things that the Peelers Council continually ignores is our production of a 2018 memorandum. And unfortunately, I don't have it to share on the screen with you today, but there's a 2018 memorandum from Mr. Kezar to the board of directors where he lists the money that's been accumulated and identified in the Burns McDonnell report and how that has changed from 2013 to 2018. And in that description, in the list of hundreds of millions of dollars that have been set aside, that have been aggregated for the purposes of paying for these damages. So the money is there, and the Peelers Council already know that. The audited financial statements have also been submitted and approved by the RUS and by the Railroad Commission. And Judge, the Railroad Commission is setting a bond. We propose a bond, but the Railroad Commission has the final say as to how much that bond will be. And they're never going to go below the amount of bond that San Miguel suggests. based on those audited financial statements and all that the Railroad Commission does, including their annual inspections of this property, they are aware of these seeps. They are dealing with San Miguel to this day with respect to seeps, and they've approved the independently audited statements. It would be fundamentally unfair, Your Honor, to excuse or to bar and exclude Mike Barrett if Charnetsky is allowed to testify. And the fact that Mr. Barrett didn't specifically talk to the auditors has nothing to do with the reliability of his opinions. At best, it goes to a cross-examination question, and we ask the court to deny this motion.
Okay. And anything from else?
Stack doesn't have anything else, Your Honor.
Your Honor, just very briefly, assuming nobody else has anything. The only thing I'd like to underline is that Mr. Schick talked about the Burns and McDonald study. He talked about a 2018 memorandum talking about the Burns and McDonald study. Apparently, they produced that. The Burns and McDonald study is relevant here, and it would have been relevant to Mr. Barrett's opinion. Again, the purpose of that study is to set forth long-term environmental obligations. That's something that wasn't provided to him. That's something that, in addition to the audit work papers, weren't provided to him. What our position is that his opinion is based on incomplete facts. While Mr. Schick stands there and says that all obligations have been accounted for, that statement is contrary to Mr. Kazar's testimony. And what we would tell the court is that, again, Mr. Barrett's opinion is based on incomplete facts. He relies on the audit. He didn't look at the work papers. He said that he would not agree with the statement that the audit is in all material respects in conformity with the accounting principles generally accepted in the U.S. And so we believe that his opinions should be excluded.
One quick point, Judge. Sorry.
Yes, sir.
With respect to the purpose of Burns and McDonald being to perform a long-term financial liability, Judge, San Miguel does that every single year. And every single year it's contained in their annual report. Every single year it's submitted to the Railroad Commission and updated.
All right, I will get this out tomorrow. I've got this and juvenile board matter. We're set for things next week or not?
I don't have the calendar in front of me. I'm sorry, Judge.
Sorry, Your Honor. No, we.
I'd been scheduled to have a jury trial, but.
I think our next hearing, Your Honor, is December 1st.
Okay.
Your Honor, we just ask again for you to review the motion for summary judgment on the lease term if you have the opportunity. Thank you.
No, I will do that. All right. I will in the meeting now. Oh, wait. Did you have a chance to look at Ms. Whittle's proposed modified scheduling order?
Your Honor, KMG did. It has no problem with it.
All right.
I have not, Your Honor.
Okay, it just.
Jennifer and I looked at it, and we believe San Miguel can agree. Jennifer and I both looked at it.
Okay.
And Judge, if San Miguel's okay with it, I trust everybody else saying it was okay, so Steck would agree as well.
Okay. All right, then I will sign off on that and send that to the clerk or e-file that in a few minutes. All right, have a good afternoon.
Thank you, Judge.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.